It's now live streaming. There you go. And thank you, Ms. Brockler.
Good afternoon, Your Honor. My name is Grant DeRose, and I'll be performing the direct examination of Taylor Perkins and the cross-examination of Alex Fuentes.
Good afternoon. You said your last name is Rose?
DeRose, yes.
DeRose, thank you. Good afternoon.
Good afternoon, Your Honor. My name is Jacob Aragon. Today I'll be giving the opening statement, as well as the direct examination of Avery Becker and the cross-examination of Kyle Kuzak. Your Honor, at this time, permission for the witnesses to introduce themselves.
Yes, Mr. Aragon, thank you.
Good afternoon, Your Honor. My name is Amanda Jin, and I am Blake Van Owen.
Good afternoon, Your Honor. My name is Henna Patel, and I am Taylor Perkins.
Good afternoon. My name is Delaney Boston, and I am Avery Becker.
Thank you. And is the defense ready to proceed? Ms. Brockler?
Yes, Your Honor. And just for the jury and for yourself, we put our roster in the chat.
Thank you very much. Before we proceed, I know you all have been through this quite a few times already this weekend, but there are a few preliminary matters that I need to take up. So first of all, I just want to make sure that I can get everybody to raise their right hands. I can't see everybody. I know we're live streaming and some of your cameras are off. And thank you. So I'm going to put you all under oath at this time. And let me get to my oath first of all. So team members, raising your hands as well as those participating as witnesses, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? And witnesses, do you faithfully and truthfully conform to your witness statements that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? If so, please say, "I do" now.
I do.
I do.
I do.
I do.
Thank you. Lastly, I know there are some gallery members, although normally it would be in my courtroom. I'll just ask that the gallery members raise their right hands, including teachers and attorneys, coaches and family members and friends. And do you promise to represent yourself as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after the mock trial round, including not involving yourselves during the competition electronically or otherwise during the proceeding? If so, please say, "I do." Thank you. And lastly, scoring panelists, could you please raise your right hands for me? Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do. I do.
Thank you. And with that, let me find out if there are any pretrial matters that I need to take up on behalf of the prosecution. Mr. Lowry.
Yes, Your Honor. There are a couple preliminary matters that we'd like to discuss.
Yes,
The
sir.
first being the people requests that the stipulated facts of the case be submitted into evidence to assist the jury's understanding of the case.
All right.
The second being the people request that the witnesses are allowed a copy of the exhibit packets and personal witness statements nearby for expediency's sake. The third being the people request that all extra time from closing statements be reserved for rebuttal. And the last preliminary matter that we'd like to discuss is the people request that all participants not actively in questioning or statements are allowed to mute their microphones.
All right. Thank you, Mr. Lowry. Ms. Brockler, are there any objections to those pretrial requests?
No, Your Honor.
And does the defense have any pretrial matters?
I think the prosecution covered it. Thank you.
Very good. With that, Mr. Lowry, are you ready to proceed at this time?
Yes, I am, Your Honor.
All right. And Ms. Brockler, you are ready to proceed?
Yes, Your Honor.
All right. Now, just a rule of thumb here, having done thousands of video trials and hearings, I am not offended if a party notices a party is muted and somebody wants to acknowledge that for purposes of the presentation. So do not be afraid, or designate somebody on your team to watch your other teammate to make sure they're not muted. All right. With that, let's take up opening statements to our jury. Mr. Lowry. Mr.
Your
Honor.
Honor, will not be performing the opening statement. That will be Mr. Tours.
Thank you. Mr. Tours, the floor is yours.
Thank you, Your Honor. It was almost a year ago today that on March 6th, 2020, this world lost a great individual. Not only a respectable family man and a talented litigator, though a dedicated mentor for numerous students at Colorado High School that looked up to him as a beacon of unwavering support and improvement. Coach Mackenzie Brackman, like so many others who assumed his altruistic and often grueling vocation of mentoring the youth, devoted every drop of his time and energy into the success of his pupils. However, when a strong and committed figure takes lead, the ones beneath them who are hosts to conflicting attitudes are left to dwell in vengeance and resentment. And today you will see that, most unfortunately for Brackman, despite all the love he vested in his team, one of his very own pupils, Avery Becker, was no different. And the result was pure tragedy. Today you will hear the testimony of three individuals, one of whom being a close companion and teammate of Avery Becker, and the other two expert witnesses here to validate the copious pieces of evidence that prove Avery Becker is beyond a reasonable doubt the perpetrator of the two charges we bring upon him today. Firstly, you will hear from expert witness Jordan Markowitz, a homicide detective with the Denver Police Department with a certification in data recovery from the American Academy of Law Enforcement. By meticulously following the data evidence, Markowitz will detail the events the day of Brackman's murder, from the location of Avery's cell phone that puts him in close vicinity of Mr. Brackman during the span of the crime, to the highly incriminating text Avery sent to Mr. Cifuentes immediately prior. Secondly, you will hear from expert witness Kyle Kuzak, a crime scene reconstruction investigator with 19 years of experience, who will provide their merited insight into the circumstances and events of March 6th that led to Brackman's murder. This includes the gruesome details of Brackman's stabbing, the very odd circumstances surrounding Brackman's reaction, as well as their professional opinion on how exactly Avery Becker committed this evil crime. For months upon months, you will see that Avery Becker had been cultivating a nasty hatred towards Coach Brackman. And while he wanted to do nothing more than retain their lead roles on the team while doing the absolute bare minimum, you will see that Avery Becker demonstrated their character by maliciously vandalizing Coach Brackman's car after Avery was demoted from the team. After Mr. Brackman expelled Avery from the team for the safety of everyone else, for the vindictive Avery, you will see that backing down was not an option. So on March 6th of last year, after days of brooding and anger and humiliation, you will see that Avery Becker texted friend Alex Cifuentes that they were escalating the hatred and going straight to Mr. Brackman's home to vandalize it. Shortly after that, Brackman was found stabbed dead on his front door. Whether it be purely the result of teenage recklessness or something deeper in Avery's character, one thing is for certain: simple coincidence is not to blame for this wicked crime. Through the ensuing testimonies and evidence you will bear witness to, we remain faithful that the force of justice will motivate each and every one of you to prosecute the perpetrator that is here with us today. Today, we bring the following charges against defendant Avery Becker. Murder in the first degree, that on or about March 6, 2020, Avery Becker unlawfully and feloniously committed or attempted to commit second-degree burglary. And during the course and furtherance of that crime, the death of Mackenzie Brackman was caused by anyone, along with second-degree burglary of a dwelling. That on or about March 6, 2020, Avery Becker unlawfully, feloniously, and knowingly broke an entrance to, entered, or remained unlawfully after a lawful or unlawful entry in the dwelling of Mackenzie Brackman with the intent to commit therein the crime of criminal mischief. We, the prosecution, have the cold hard evidence. We have the only likely outcome, and right here today in this courtroom, we have a murderer awaiting sentencing. Now for you, the jury, you only have one thing to do today. You have the duty and the opportunity to choose facts, to choose evidence, and to choose justice today. Thank you.
Thank you, Mr. Tours. And would the defense like to make an opening statement at this time?
Yes, Your Honor. And before I begin, can you see me all right and hear me all good?
Yes, sir. Thank you.
Avery Becker did not break in to Mr. Brackman's home. Avery Becker did not kill Mr. Brackman. Avery Becker is not guilty. You see, Avery Becker was a former high school student. She had a passion for the law, and she was a decorated mock trial competitor. On top of that, she was a community member, a daughter, and a good friend. In fact, on March 6th, she spent the entire day with her friend, Taylor Perkins. They went to the mall, the Fry Shack, and home. They never saw Mr. Brackman. They never even talked to Mr. Brackman. And she certainly never did the things the prosecution wants you to believe that she did. Avery Becker now finds herself being a target in a criminal investigation. Investigation that was rushed, sloppy, and lacks any real evidence tying Avery Becker to the crime. The prosecution has the burden in this case. Today they are charging Avery Becker with 2 charges: burglary in the 2nd degree and murder in the 1st degree. They must prove to you each and every element beyond a reasonable doubt. It is the highest burden in our legal system. And if you walk away with not one element being proved, then you must find Avery Becker not guilty. If you walk away today with any reasonable doubt at all, then you must find Avery Becker not guilty. The prosecution will not meet their burden in this case. Today, the prosecution will leave you with 3 questions that go unanswered. 1, does the prosecution explain when this murder occurred? And as we will have to tell you, they can't and won't. 2, does the prosecution ignore other reasonable alternate suspects? And as we will have to tell you, they did. And 3, does the prosecution have any evidence at all tying Avery Becker to the scene of the murder? And as we will have to tell you again, they don't. You'll hear from 2 prosecution investigators today. You'll hear from Detective Markowitz, the lead investigator on this case. And he will tell you this case begins and ends with Avery Becker. This was the first and only lead that he found. Next, you'll hear from Detective Kuzak, who reconstructs the crime scene. The prosecution has 2 detectives at the crime scene and no physical evidence to tie Avery Becker to the scene. The investigators did not collect DNA, fingerprints, blood samples, hair follicles, clothing fibers, or any other form of evidence that could connect anyone to this crime. So after not finding any DNA or fingerprint leads on the crime scene because they did not collect the evidence, the prosecution's next best option was to, of course, check out the high school mock trial team, a team that the victim coached for, to find possible suspects. The prosecution is asking you to take leaps, unreasonable leaps, to conclusions in this case that they do not have the facts to back up. You members of the jury, you should demand the prosecution show you any evidence at all tying Avery Becker to the scene. That is their burden and their burden alone. They brought the charges. Now they have the responsibility of proving them. And as you'll see today, they're not able to do that. There are massive holes in this case. And you members of the jury, you're able to see each and every one of those holes. This was a rushed investigation. This was a rush to judgment. Avery Becker is not guilty. Thank you.
Thank you, Mr. Aragon. All right. Prosecution, are you ready to present and call your first witness? And Mr. Lowry.
Yes, Your Honor, we are. The first witness that we'd like to call to the stand is Detective Miss Jordan Markowitz.
Right. Ms. Markowitz, if you would please take the stand.
Ms. Markowitz, can you hear me?
Yes.
Okay, wonderful, wonderful. May you please state your name and spell your last name for the official court record?
My name is Jordan Markowitz, Markowitz.
And Ms. Markowitz, what's your occupation?
I'm a homicide detective with the Denver Police Department.
And how long have you been in that position?
I've worked with the DPD for 13 years. However, I've been a detective for 7 of those years.
And do you have any specialized knowledge pertaining to this case?
Yes, I have specialized knowledge in forensic data recovery and cell phone technology. I hold a certification from the American Academy of Law Enforcement in these subjects.
And when you got your certification from the American Academy of Law Enforcement, what did you learn during that training program?
I learned a lot about cell phone technology and forensic data recovery. I learned how to download the contents of a cell phone using forensic systems like the Celebrite system, how to obtain and interpret cellular records, and how to obtain and interpret cell tower data.
And how often do you use that training in your daily job?
I've downloaded the contents of hundreds of cell phones and used my expertise on cell tower technology in over 50 cases.
Your Honor, the prosecution moves to tender Jordan Markowitz as an expert in homicide, cell phone technology, and forensic data recovery.
Thank you, Mr. Lowry. Ms. Brockler, would you like to do voir dire, or do you have any objection to the qualifications as requested?
I'd love to do a brief voir dire.
You may.
Good afternoon, Detective Markowitz. I just have a few quick questions for you. You have a lot of training and education in the field of cell phone data and analysis.
Yes, as well as experience.
And you certainly have experience as a homicide detective.
Yes, 7 years.
But fair to say, you're not an expert in blood spatter analysis.
No, I'm not. I don't claim to be.
You're also not a forensic scientist.
I'm not a forensic scientist. However, I do have expertise in forensic data recovery for digital pieces of evidence.
You don't test DNA.
No, I don't. I'm not a forensic.
Or detective analyze the results of those tests.
No, I do not.
You're not a medical examiner.
No.
In fact, you don't have any medical training at all.
No, I don't. I am a detective.
Your area of expertise is really just around the historic cell phone data.
Yes, as well as forensic data recovery and downloading cell phones.
Judge, the defense does not object to this witness being accepted as an expert in the field of cell phone data recovery. I can't remember the verbatim term that they used, but we just want to make sure that their expert testimony is limited to that field and they're not providing improper expert opinions in the areas of DNA analysis, blood spatter analysis, and the like.
All right, thank you, Ms. Brockler. Mr. Lowry, response?
Yes, Your Honor. Under Rule 702, testimony by expert witness, Ms. Markowitz has proven that she has had expert and technical experience in a specialized field such as homicide, where she has worked for 7 years. That is plenty of experience, and that is recent experience as well. This gives her an analysis of processing crime scenes, canvassing crime scenes, looking around crime scenes, finding key suspects. And she also has a proper education in finding out and how to use and interpret cell phone tower and data records.
All right, thank you, Mr. Lowry. For purposes of the presentation here today, I will admit the witness as an expert as requested, acknowledging Ms. Brockler's request to limit the expertise. I'll caution the jury just to balance the weight and evidence presented and consider her expertise as qualified. You can proceed.
Thank you, Your Honor. So Ms. Markowitz, can you please describe the events of March 6th, 2020?
Certainly. I arrived at the scene of the crime at about 2:20 p.m. My officers were already there as they had received a call from a passerby suspecting that the victim was passed out on their porch. Upon our arrival, it was clear that Mr. Brockman had actually been murdered. They were stabbed in their upper left shoulder with the murder weapon lying nearby.
Let the record reflect, it is expected that the witness is looking at a clean and unmarked copy of what has been previously marked as exhibits 1, 2, 3, 4, and 5, and 6. Ms. Markowitz, do you have those exhibits next to you? And Your Honor, do you have those exhibits near you?
I do have them available and pursuant to the opening request, I believe Ms. Brockler, the defense has those as well.
Yes, Your Honor, we have a copy of all the exhibits.
Thank you.
The prosecution would like to move these exhibits that I just stated, exhibits 1, 2, 3, 4, 5, and 6 into evidence.
Ms. Brockler?
Your Honor, I'd like to see a little bit more foundation laid for these exhibits, and I'd also like to limit the number of exhibits that are coming in, especially exhibits 1 through 4, which are pictures of the bloody murder body, because those could be unfairly prejudicial for the jury, because those are very gruesome.
Right. Mr. Lowry, any response to
I can
request to limit?
Yes, Your Honor, we can definitely limit the amount of exhibits admitted. I'd like to start by admitting exhibits 1 and 2 into evidence.
Again, Your Honor, can I ask for some more foundation on those?
So I'll sustain that. Mr. Lowry, why don't you lay a little more foundation on the exhibits, how they came to be and her knowledge of those?
Yes, sir, I can do that. Ms. Markowitz, what conclusions did you draw from the scene?
Well, I was able to see by the location and the position of Brackman's body that it was most likely they were headed out of the residence when they died and they were stabbed in the back.
And did you notice anything else from the body at the crime scene?
I was able to recover the cell phone, and I also noticed that he had a shirt on that said, "Keep calm and mock on," a reference to mock trial.
Okay. Now, Your Honor, I'd like to admit these exhibits into evidence purely for the sake of the jury to view exactly what the expert witness is talking about so they can see the body of Mr. Brackman.
Great, thank you. Anything further, Ms. Brockler?
Again, Your Honor, I don't think proper foundation's been laid. We don't know the state of these exhibits and how they are in relation to when Detective Markowitz actually observed this scene. We don't know how she documented these exhibits.
I can proceed to lay further foundation, Your Honor.
Mr. Lowry, go ahead.
Ms. Markowitz, when did you arrive on the scene?
I arrived at the scene at 2:20 p.m. after my officers arrived. The forensic team began processing the scene at around the same time.
And did you canvass anything else from the scene beyond what you initially saw?
Yes, I did walk around the house to check that there was nothing stolen and no further victims.
Okay. And Miss Markowitz, what anything else, other items that you found in disarray, general splatters all over the floor and stuff like that we can see in the exhibits? Did you see anything out of the ordinary in the home?
I did see a knocked over chair, a broken plate, and scuff marks near the back of the house. I also noticed blood cast off marks on the wall.
Let the record reflect it is expected that the witness is looking at a clean and unmarked copy of what has been previously marked as exhibit number 9. Do you have exhibit number 9 next to you, Miss Markowitz?
Yes.
Your Honor, do you have exhibit number 9 at your side?
I do. Thank you, counsel. Ms. Brockler, have you seen a copy?
I've got a copy. Thank you.
Yes. At this time, I would like to admit exhibit number 9 into evidence for expediency's sake of helping the jury understand of what the witness is describing in the pictures when describing disarray in the house.
All right. Ms. Brockler, any objection?
Again, Your Honor, I'm going to object to lack of foundation. We don't know the process between documenting these exhibits. We don't know if these are fair and accurate representations of the crime scene. We don't know how Ms. Markowitz has personal knowledge of these exhibits. We just need a little bit more foundation.
Mr. Lowry, I agree. Maybe you could have her explain how she knows of these documents and exhibits and how she has viewed them perhaps before.
Yes, Your Honor. Ms. Markowitz, in exhibit number 1, what do you see?
Well, I see the photo that was taken by the forensic team of Mr. Brackman's body and the front door.
In exhibit number 2, what do you see, Ms. Markowitz?
I see a photo taken by the forensic team of Mr. Brackman's body from a separate angle where you are able to see the stab wound.
Okay. In exhibit number 3, Ms. Markowitz, what do you see?
It is similar to Exhibit 2,
Objection, Your
except
Honor.
it's a
I'm going to object to best evidence. Ms. Markowitz is talking about this evidence, but it hasn't been actually admitted yet.
Mr. Lowry, any response?
No, Your Honor, my opposing counsel is correct, and I do need to admit this into the evidence. So I can move on into my line of questioning.
Sure. So I'll just caution the witness, try not to talk about what you observe in the documents until they're admitted, but you can talk about how you're familiar with the document itself. So
Yes, Your Honor.
go ahead.
Ms. Markowitz, upon your arrival, you said that you were not the first person at the crime scene, yes or no?
No, I was not the first person at the crime scene. My officers arrived before me.
And for over 13 years of service and 7 years as a homicide detective, Ms. Markowitz, you have been tendered as a expert in homicide. Is that correct, Your Honor?
Objection, Your Honor. I'm not sure if this is a question, but that was leading.
Oh no, I'm sorry. I can rephrase if it contradicts. Ms. Markowitz. So we've learned that you drew the conclusions that Mr. Brackman, the house was in general disarray, and Mr. Brackman was lying dead, bleeding out in his hallway. Is this correct?
Yes, Mr. Brackman was lying in a pool of blood when we arrived.
Okay. Ms. Markowitz, I'm going to move on from this line of questioning. And did you return to the crime scene and learn anything else from Mr. Brackman's body?
I was able to.
Your Honor, compound question.
Did you return to the crime scene, Ms. Markowitz?
I was already at the crime scene.
Okay. Did you learn anything else from Mr. Brackman's body?
Yes, I was able to retrieve Mr. Brackman's phone from his body, which is how I got the passcodes for his Ring doorbell account. It's also how I discovered how deep his connection was to mock trial at the Colorado High School, which is why I contacted the school for a list of members participating in that club, which is how I learned about Alex Cifuentes.
And what did you learn from Mr. Cifuentes?
I scheduled an interview with Mr. Cifuentes, and I received a screenshot of text messages sent from Avery Becker to Mrs. Cifuentes, claiming Avery Becker was going to trash Brackman's home.
Objection,
They were
Your
not
Honor.
allowed back on the mock trial
Hearsay.
team.
Wait, hold on. Ms. Brockler?
I was objecting to hearsay. I'm not sure if my mic cut out there.
Mr. Lowry, any response?
We can move on in the line of questioning, Your Honor.
All right. Thank you, Mr. Lowry.
Did you have communication with Mr. Cifuentes, Ms. Markowitz?
Well, I did interview Ms. Cifuentes, and she emailed me the screenshots of this incriminating conversation later.
Do you have a clear and unmarked copy of exhibit number 14 next to you, Ms. Markowitz?
Yes, I do.
Your Honor, do you have a clear and unmarked copy of exhibit number 14 next to you?
I do, Mr. Lowry. Thank you.
And my opposing counsel, do you have exhibit number 14 next to you?
I've got one, thank you.
Yep. Your Honor, I'd like to move exhibit number 14 into evidence on the grounds that it is screenshots that was sent from a conversation that Mr. Cifuentes had with Ms. Markowitz and regarding the whereabouts of the conversation that Ms. Becker had with Mr. Cifuentes.
All right. Ms. Brockler, any objection?
Yes, Your Honor, I'm going to object to both lack of foundation and hearsay.
Okay.
So the court will overrule the objection. The witness who's been qualified as an expert testified to taking possession of the phone, and she's describing what she reviewed and the information contained therein. So I'll omit these exhibits for purposes of her relying on information she obtained and her opinion. So
Your Honor, can I specify the hearsay objection? Can I specify the hearsay objection?
You may.
This is hearsay within hearsay. These aren't texts between Ms. Markowitz. It's also disputed that these are not texts from the defendant, so therefore they cannot be a statement by a party opponent. And when it comes to Ms. Markowitz's investigation, these are being offered for the truth of the matter, so cannot be accepted in the court.
Your Honor, if I may, I misspoke and would like to strike my initial from the record. I would like to admit Exhibit 14 onto the record into evidence, as it is screenshots that Mr. Cifuentes sent over email to Ms. Markowitz. It is not a conversation between Ms. Markowitz and Mr. Cifuentes. I'm sorry if that was not clear or if I did not clarify that in the best way possible.
That is the reason for my hearsay objection, Your Honor. Not the clarification, sorry. The clarification, yes, because they are not conversations involving Ms. Markowitz.
Okay. There are conversations directly relating the possibility that Mr. Cifuentes and Avery Becker were in connection and collaboration.
All right. Since the witness is testifying as an expert, and these are documents that she received, and I believe one or more of the witnesses involved in this text will be testifying and under subpoena. I'll allow it to come in subject to cross-examination, noting the hearsay objection by Ms. Brockler.
Thank you, Your Honor. Ms. Markowitz, did you follow up with this information with Mr. and Mrs. Becker regarding this Exhibit 14 and the screenshots of the text messages?
I did attempt to schedule an interview with Ms. Becker. However, their lawyer canceled the interview. I also attempted to download the contents of Becker's phone to verify these texts, but I was told that the phone was missing since March 5th.
I'm sorry, continue.
Oh, no, thank you. I was done.
Was there a court order to retrieve Mr. Becker's phone?
Yes, the phone number was provided by his attorney, her attorney.
And what did you recover from the phone?
I was able to recover the call detail records for Avery Becker's phone from the day of the murder.
And what are the specific call detail records on this case?
Well, to clarify, call detail records depict the time and location of phone calls and texts received from a certain phone number over a specific time. We're able to tell this because it gives us the specific cell tower it went through and the direction it went through. In this case, we're able to use that to track Avery Becker's movements from the first text received at 12:47 p.m. until the last text message received at 1:17 p.m. at the Brackman residence.
Did you figure out who the communications were with on the CDRs?
Yes, I was able to confirm that it was Taylor Perkins sending the calls and texts to Avery Becker during the time of the murder.
And Ms. Markowitz, when did the Avery Becker's phone records cease to exist?
They ceased to exist at about 1:20 p.m. on March 6th. This would be approximately 3 minutes after Avery Becker left the Brackman residence.
And Ms. Markowitz, do you have Exhibit 15 and 16 next to you?
Yes, I do.
And Your Honor, do you have Exhibit 15 and 16?
I do, thank you.
Co-counsel?
Got it, thank you.
Awesome, thank you. Ms. Markowitz, what is portrayed in Exhibit 15?
This is my diagram of the call detail records received on March 6th.
And what about Exhibit 16?
This is the same diagram, however, I've labeled the most likely path that Becker took from their house to Brackman's house on that day.
Your Honor, I'd like to move Exhibits 15 and 16 into evidence.
Ms. Brockler?
No objection.
All right, the court will admit these as demonstrative exhibits. Mr. Lowry.
Ms. Markowitz, in Exhibit 16, what is the blue dotted line?
The blue dotted line indicates the most likely path that Becker took from their house to Brackman's house on March 6th.
In your professional and expert opinion, would you say Avery Becker had intent to break in and vandalize Mr. Brackman's residence?
Yes, I believe they did. They clearly stated it to Alex Cifuentes, and they obviously took their threat too far.
And do the call detail records back up your expert opinion?
Yes, they do. It demonstrates Avery Becker making their way to the Brackman residence on the day of the murder.
Thank you. That will be all at this time. No further questions.
All right, thank you, Mr. Lowry. Ms. Brockler, would you like to do cross-examination?
Yes, Your Honor.
You may
Good
proceed.
afternoon again, Ms. Markowitz. As a detective, especially a lead detective, you know that it's important to do a thorough investigation,
Yes, I always follow where the evidence leads me.
to follow all appropriate leads,
Yes, I follow the evidence.
and to identify and collect all relevant evidence.
Yes.
So now let's talk about what you did and did not do in your investigation. In this case, we know that the intruder tried entering through the front door,
Yes, that is clear from the Ring doorbell videos.
but they ended up entering through the back door.
Yes.
Yet you did not have those doors checked for fingerprints,
No, they were wearing gloves.
and you did not have those doors swabbed for DNA.
No, because once again, the defendant was wearing gloves.
But again, detective, you're no expert in DNA. You don't know how the gloves affect transference of DNA, correct?
Yes, but I have trust in my forensic team.
Speaking of DNA, you testified that you found blood drops in the dining area.
I did notice blood splatters on the wall from cast-off marks.
Yet you didn't have those tested for DNA either.
No.
And you would agree, detective, that if those blood drops did not belong to the victim, that would be extremely relevant in today's case.
Yes, but I am not an expert in forensic science, so that would have been up to my forensic team.
So that's a yes, detective?
I'm sorry, could you repeat the question?
That if those blood drops did not belong to the victim, that would be extremely relevant in today's case.
Yes, that would be relevant, but it's unlikely that that happened.
You didn't even collect that blood as evidence.
No, we did attempt to take pictures of it, however, they were corrupted, unfortunately.
Right. You claim that you took photographs of this blood,
Yes, photographs were taken.
but this jury won't get to see those
It is very unfortunate they were corrupted.
because you lost the evidence.
No, I did not lose the evidence, they were corrupted.
But that's not the only thing that was lost in this investigation. Let's talk about your leads. As a detective, you should never try and take the case where you think it should go, correct?
Yes, why I follow the evidence.
Right. You follow the evidence and you go where it takes you. Is that
Yes.
correct?
Yes.
Good police work requires you to follow up on all possible leads.
Yes, it does.
And in this case, the evidence showed that the victim was a somewhat well-known criminal defense attorney.
Yes.
That fact made you worry that the murder could be the work of a disgruntled ex-client,
That was my initial assumption before viewing the evidence.
and that it was highly unlikely that the victim's mock trial activity had anything to do with it.
Once again, that was my initial assumption, but that is not where the evidence led me.
But that's a yes, detective. It was highly unlikely.
At first, yes, but the evidence does make it clear that that is not unlikely.
But you did nothing to look into the victim's former clients.
No, Mr. Brackman has been a litigator for many, many years. That would be a
Detective.
very long list of
Detective.
potential
You
suspects.
can get into your explanations on redirect. I'm just asking if you did or did not look into the victim's former clients. That's a no, correct?
Correct.
Instead, what you did was contact the local high school to get the names of all of the mock trial students the victim worked with.
Yes, Brackman clearly spent more time on mock trial than he did on his own job.
Even though that theory was highly unlikely.
Yes, but like I said, I follow all the evidence and leads.
Now, how many students are on that mock trial team, detective?
I'm not aware of exactly how many students.
So you're the lead detective in this case and you can't tell us the number of mock trial students that you interviewed?
I would make the assumption that it was about 12, but I'm not positive on how many members of the team they had.
As an officer, you attended a police academy, correct?
Yes, I did.
And in that academy, they teach you report writing skills.
Yes.
That it's important to document everything.
Yes.
Objection, Your Honor, outside the scope of the witness on the last question regarding talking about police training.
Ms. Bruckler, response?
Your Honor, this witness has been tendered as an expert in the field of investigation and somewhere in the realm of policing. I can't remember the verbatim word, but I think it's very relevant, the training that she's had in her police work in this case today. And that definitely is within her scope.
Any further response, Mr. Lowry?
No, Your Honor, not this time.
All right. I think it goes to her credibility as her expertise credentials have been presented. So I'll overrule the objection. Go ahead.
That it's important to document everything. You learned that, correct?
Yes, I did.
Including what witnesses you spoke to
Yes.
and what those witnesses told you.
Yes.
This is important because, as you know, the district attorney relies on your report in determining what charges to bring.
Yes.
You also know that defense attorneys, like myself, also rely upon those reports to prepare a case.
Yes.
So what you put in your report matters.
Yes.
And what you fail to include in your report also matters.
I suppose so.
So that's a yes, detective?
Yes.
Now, in this case, your report only mentions Alex Cifuentes, Avery Becker, and Taylor Perkins as mock trial students.
Yes, those are the people that I spoke to.
But you also spoke to a student by the name of Brandon Digby,
Yes, suppose so.
although that interview is nowhere in your report.
Yes, they most likely didn't have anything relevant to the case.
You also spoke to another student by the name of Josiah Mitchell,
Yes.
although that interview is not documented in your report.
Once again, they likely had nothing relevant to the case.
Now, let's talk about what other evidence you failed to collect and document. You never downloaded the text message data for Alex Cifuentes' phone.
No, I did try to corroborate it with Avery Becker's phone. However, the phone was conveniently missing.
Yet, detective, you have training and experience in data recovery from cell phones.
Yes, I do.
And as a detective for the past 7 years, you've downloaded the contents of literally hundreds of cell phones.
Yes, I have. I have a lot of experience with it.
Alex Cifuentes told you that they had a text exchange with Avery Becker that almost amounted to a confession. Isn't that right, detective?
Yes, it was very explicit.
And this evidence, for lack of a better term, was paramount in your case.
Yes, it did initially lead me to Avery Becker. However, it is not the only evidence pointing to Avery Becker.
Because it provided you with a motive for Avery Becker.
Yes, but so does the testimony of
Detective, I'm
several
just
other
asking for
witnesses.
a yes or no here. So you just had these high school students send you a screenshot of these texts,
Yes, it's frequently considered reliable evidence in my line of work.
even though you just told us that the common course of action would be to get a downloaded contents of that phone.
Yes, Alex did also get a new phone recently, so I was unable to download the contents of his phone, her
To
phone.
get an untampered record of the actual text messages.
Yes, but I do consider the screenshots to be reliable evidence on this.
And your police department has the software to get this untampered record, correct?
Yes, the Celebrite system.
And you
Question,
personally,
Your Honor, asked and answered.
Ms. Brockwood?
I haven't asked that question yet.
So I think she was going into a new line of the method of collection. So I'll allow some leeway here, Mr. Lowry. Go ahead, Ms. Brockwood.
I'll re-ask the question. Your department has the software to download these cell phones, correct?
Yes, that would be the Celebrite system.
And you personally have the training to execute that action,
Yes.
but you failed to do so.
I did not download the contents of Alex Cifuentes' phone, if that is what you're referring to.
So that's a yes, detective?
I didn't download the contents of Alex Cifuentes' phone. I'm not positive if that's a yes.
Yes, you failed to download the contents. However, you got a court order for Avery Becker's cell phone records.
Yes, I did.
And it's your opinion that Avery Becker was near the victim's house at the time of the murder.
Yes, the CDRs clearly show their location.
So let's talk about when this murder occurred, because the time of the murder is extremely important in this case. Isn't that right, detective?
Yes.
Because the time of the murder is what makes your cell phone records relevant.
Yes, it is.
And those are the only thing that ties Avery Becker to the crime scene.
Well, along with the explicit text messages.
Now, we know that the first event that happens is a 911 call that comes in. Isn't that correct, detective?
Yes. I believe my officers were contacted.
Yeah, that 911 call. What time does that 911 call get placed, detective?
I believe it was sometime between 1:20 and 2:20 p.m.
Detective, that's nowhere in your report.
That would be logical, considering that would be around the time, between the time that Brackman was murdered and the time that I arrived on the scene.
Detective, I'm not asking you what's logical. I'm asking you what's in your report. Please do not make up facts outside of your witness statement. Okay,
Well, then-
I'll sustain my objection or recant it.
we know what happens after the paramedics arrive on scene. What time do the paramedics arrive?
I am not positive.
It's not in your report. You also have no idea what time the intruder entered the home.
Well, aside from Avery Becker's phone records, no.
You don't know when they left the home either.
No, there is no timestamp on the Ring doorbell.
That's right. So it could have been around, I don't know, 12:45 p.m.?
That's unlikely.
But it could have been around there because we don't know the time. Isn't that right, Detective?
Yes, we don't know the exact time that they entered the house.
But 12:45 is the time that you placed Avery Becker at her own home,
Yes, but it's very unlikely that the intruder entered earlier than that.
which is nowhere near the victim's home.
It's not very far from the victim's home, but I wouldn't say nowhere near.
Thank you. No further questions.
All right, thank you, Ms. Brockwood. Mr. Lowry, redirect.
Not at this time, Your Honor.
All right. Thank you for your testimony. You can go ahead and step down from the witness stand.
Thank you, Your Honor.
Great. Prosecution, will you be calling your next witness? And Mr. Iode?
Yes, Your Honor. The prosecution would like to call Kyle Kuzak to the stand.
All right. Kuzak, come on up to the stand. And here's your witness.
Good afternoon. Please state your name, spell and the last for the court.
Kyle Kuzak, Kuzak.
And what do you do for a living, Ms. Kuzak?
I'm a Colorado Bureau of Investigation certified crime scene reconstructor, also known as a CSR.
And how long have you been working as a CSR?
I have 19 years of experience investigating complex crime scenes.
And what does your day-to-day look like as a CSR?
Investigating complex crime scenes includes home invasions, burglaries, other property crimes, domestic violence, fatal accidents, and other things.
And who are you working for right now?
For the past 3 years, I've been with the Denver Police Department as a civilian employee.
And why have you been called into court today?
I'm here to testify my expert knowledge of the events that happened on March 6, 2020.
Your Honor, I motion to enter Ms. Kuzak as an expert in crime scene analysis, reconstruction, and investigation.
All right, thank you. Defense, do you have any objection to that?
Yes, I have a brief voir dire, Your Honor.
Yes, Mr. DeRose.
Second.
Mr.
All right.
Harris, apologize.
Oh, it's okay. Don't worry about it. Good afternoon, Ms. Kuzak, or is it Investigator Kuzak? I'm a little confused here.
I'm Kyle Kuzak.
Okay, just to be clear, you're not a police investigator.
No, I'm a civilian employee, but I'm certified by the Colorado Bureau of Investigation.
Right, you never have been a police officer.
Objection, Your Honor, relevance.
Counsel?
Your Honor, this just goes to discredit the credibility that the witness has when it comes in the field that she's being tendered in. She was tendered in a field of investigation, and I'm trying to prove she doesn't have the necessary qualities in order to be tendered in the field of investigation.
Your Honor, if I may respond.
You may.
It's not directly relevant for somebody to work for a police department in order for them to be credible.
Okay. So since this is wide, dear, I'll allow some latitude with regard to her expertise and area of expertise. So I'll overrule the objection and certainly can take that up on argument, counsel. Go ahead.
And you never have been a police officer.
No, I have not.
So you've never gone to the police academy,
I've never gone to the police academy.
never even responded to a call for service as a patrol officer.
No, that is not what my job entails.
You've never led an investigation as a lead detective.
No, I'm not a detective.
You don't have any specific training in forensic cell phone data analysis.
No, I do not.
You aren't certified as a forensic cell phone data analyst.
No, I'm not.
Honor, objection on the grounds of relevance. I'm not trying to enter my witness as anything involving with a cell tower analysis.
Mr. Hargan?
Again, Your Honor, this is just question her credibility, and especially on the things that she's able to opine upon. I'm trying to prove that she has no training or anything when it comes to investigation and how she's able to reconstruct this crime scene.
Mr. Rayotti, anything further?
I don't see how reconstruction of a crime scene relates to cell tower analysis.
So I tend to agree with the objection. If you can try and keep your voir dire within the scope of the expertise they requested, that would be helpful. Thank you.
Yeah, of course. Your entire basis for what you claim is your expertise is your certificate of crime scene reconstruction.
Yes, from the Colorado Bureau of Investigation.
Right, which is based on what you claim are scientific principles and methods.
Yes, and I have over 19 years of experience where these methods have worked.
Right, specifically the 7-step methodology for an event analysis.
Yes.
And you claim you reliably applied those principles and methods to the facts and data in this case.
Yes, it helps keep me very organized and make sure that my expertise can be easily conveyed to the people I'm trying to convey it to.
Right, but how many steps did you follow in this case for crime scene reconstruction?
I mainly followed the 5 steps that I deemed were the most important.
Your Honor, the defense objects to this witness being tendered in the field of crime scene reconstruction and analysis and investigation. First, this witness lacks the requested training and experience required under Rule 702. They gave no formal training in any areas of crime scene investigation. Their only basis of knowledge comes from a certificate in which they call crime scene reconstruction. But more importantly, in order for a witness to testify as an expert, they need to not only base their opinions on reliable scientific principles and the methods, but they must apply those same scientific methods to the case at hand. And this witness has already demonstrated through the voir dire that they did not follow the 7-step method. Therefore, their opinions are invalid.
All right, thank you. Any response, Mr. Alito?
Yes, Your Honor. While it is true that she has never received formal education for these fields, she has been working in this field for 19 years. I'd assume that that makes her enough of an expert to speak on this topic.
All right, having considered the testimony, the voir dire, and the court does find that based upon her experience and her area of expertise regarding crime scene reconstruction investigation is sufficient. I'll allow her to testify in that area. You may proceed.
Thank you, Your Honor. Where were you the evening of March 6th, 2020?
I visited the scene of the crime at 444 South Flower Street after it was investigated by other members of the crime lab.
And why did you arrive after the other members of the crime lab?
As a civilian employee, I let the official police do their investigation before I conducted mine.
What was the first step in that investigation?
I created a witness tracking spreadsheet and an evidence tracking spreadsheet.
And why would you create a document like that?
To make sure that all my information in my investigation was organized and so that I convey it to other people with ease.
Let the record reflect that Kyle Cusack should be looking at a unmarked copy of Exhibit 17. Do you have a copy of this in front of you?
Yes, I do.
Opposing counsel, in your honor, do you have a copy of Exhibit 17?
Mr. Aragon?
Yes, Your Honor.
The court does as well. Thank you.
Can you describe what Exhibit 17 depicts?
This is the spreadsheet I just talked about.
Thank you. Your Honor, I motion to enter Exhibit 17 into evidence.
Mr. Aragon, any objection?
Yes, I object to lack of foundation. Again, we don't know if this is the same or similar condition as she last saw it. There hasn't been a proper foundation of how she was able to apply this to her case today, and if this is the same document that she even used overall.
Your Honor, I believe that I laid proper foundation for this exhibit as I've given 3 questions on what the exhibit is and why she has used it.
What I'll do is, noting the objection, Mr. Aragon, it appears that she created this exhibit, so you can cross-examine her on the validity of that and the condition. So I'll admit that exhibit.
Thank you, Your Honor. In this report, you mentioned blood droplets, but there's no evidence of this. Why is that?
Yes, the files with the blood droplets became partially corrupted after I conducted my analysis of them. However, I had no problem accessing them for my investigation.
Thank you. And what was the first step in investigating this case after you completed your report?
I established multiple timelines of events so that I could best determine what is the most likely thing to happen on the day of the crime.
And on the day of the crime, in your professional opinion, when do you believe the criminal activity began?
When the perpetrator tried to open the door without knocking and wearing a full face mask and found the door locked.
And was there any evidence of this?
Yes, there was a Ring doorbell video taken.
Do you have a copy of Exhibit 10?
Yes, I do.
And can you describe this Exhibit 10?
Yes, Exhibit 10 is a video of the intruder walking up to Mackenzie Brackman's front door.
Thank you. Your Honor, I motion to enter Exhibit 10 into evidence.
Mr. Aragon, do you have a copy of that exhibit?
I do, Your Honor.
All right. Do you have any objection to Exhibit 10?
Not this time, Your Honor.
All right.
Thank you.
Exhibit 10 will be admitted.
Thank you, Your Honor. And after the intruder is depicted in Exhibit 10, where do you believe they moved in your professional opinion?
I believe that the intruder moved around to the back of the house where they were caught by another Ring security camera and then caught again by another security camera when entering the back door.
Thank you. And based on your professional analysis of the crime scene, what do you think happened near the back door?
I believe that the perpetrator made it inside and the victim ran for the knife block if they didn't already have a weapon from when the Ring doorbell went off in the first place.
And in your professional opinion, was there any pieces of evidence that made you believe something happened near the back door?
Yes, just inside the back door, there are scuff marks, and these could be from anything, but I doubt a man with the prestige, in my professional opinion, of his stature and the way he carries himself through my investigation would have scuff marks there. But that is just my professional opinion.
Thank you. And do you have a copy of Exhibit 18?
Yes, I do.
And Your Honor and opposing counsel, do you have a copy of Exhibit 18 as well?
Mr. Aragon?
Yes, Your Honor.
The court
Can you
does.
please, oh, sorry. Can you please describe to the jury what is depicted by Exhibit 18?
Yes, these are the scuff marks that I just previously mentioned.
Your Honor, I motion to enter Exhibit 18 into evidence.
Mr. Aragon?
Again, lack of foundation. Specifically, these are photographs that Ms. Cusack did not take herself. Therefore, we don't know if they're in the same or similar condition or if there's been any tampering at all. Therefore, there's an overall lack of foundation.
Mr. Alito, any response?
I would respond in saying that I have laid proper foundation and that Ms. Cusack has used these in her investigation. Therefore, they are relevant and they have been explained.
Okay. To the extent that she's described them and they appear to be what she observed, that might be a good question to clarify, Mr. Alito. Other than that, I would admit that.
Thank you. In your professional opinion, what did these scuff marks indicate?
These scuff marks indicate that there is a high probability that there may have been a struggle in the kitchen immediately inside to the right of the back door.
And taking a look at your professional analysis of the crime scene, are there any indications of what may have happened after that initial struggle?
Yes, there is a missing knife from the knife block, which is potential for the murder weapon, as well as a broken plate on the floor, and further indicating the struggle.
Thank you. Do you have Exhibits 5 and 8 in front of you?
Yes, I do.
Okay, thank you. And you mentioned a knife block, correct?
I did.
Taking a look at Exhibits 5 and Exhibits 8, can you please describe to the jury what these are?
Yes, Exhibit 5 is the murder weapon used, and Exhibit 8 is the knife block that I just previously mentioned, and it is the same photograph that I was looking at during my investigation.
Thank you. Your Honor, I motion to enter Exhibits 5 and 8 into evidence.
Mr. Aragon, do you have copies of those exhibits? And if you do you have any objection?
I do have a copy and I object to best evidence.
Best evidence.
Any response, Mr. Alito?
I believe that these are the original copies.
So what I'll do is she testified as to what she observed. I think there maybe need to be some clarification regarding her statement that Exhibit 5 is the murder weapon. However, she did testify to what she observed. Yeah, so I'll allow it to come in, but I'm going to need more information on Exhibit 5 and the murder weapon.
Okay, thank you. Moving on, do you believe the perpetrator came with a weapon?
In my professional opinion, I believe that it is highly unlikely that the perpetrator came with a weapon because, as I mentioned, as in the ring doorbell footage that I previously mentioned, there is no sign of a weapon on the perpetrator.
Thank you. And in your professional opinion, why would the perpetrator come to the house without a weapon?
I believe that it is only that the perpetrator only came with intention to break and enter.
Taking a look at the text from Exhibit 14, would you say the intentions of the perpetrator and the intentions of the person texting match?
Object, Your Honor, compound question.
Your Honor, I'm not asking two things. I'm asking for my witness to compare two things.
As well, Your Honor, I also object to leading.
So Mr. Leo, maybe you could tackle it one question at a time regarding the particular exhibit if she knows it, and then how it refers to her opinion.
Thank you, Your Honor. So taking a look at the text from Exhibit 14, what would you say the intent of the sender was?
I believe, in my professional opinion, that Exhibit 14 indicates that Avery Becker in these text messages only had intent to break and enter, not to murder.
And would you say the perpetrator matches that intention?
Yes, I would agree with that.
Thank you. Detective Van Owen has a theory that the victim was snuck up on and surprised by the perpetrator. Could this be the case?
I believe that his theory is extremely flawed because of the evidence that I've just presented.
All right. Thank you. No further questions.
All right. Thank you, Mr. Alito. Mr. Aragon, did you want to have cross-examination of this witness?
Yes, Your Honor.
You may proceed.
All right, Investigator Kuzak, before we tackle your opinions in this case, let's first be clear on what you did and did not do in this case. You claim that you conducted a thorough, comprehensive investigation,
Yes, that is what I believe I did.
but you are not part of the initial investigation.
No, as a civilian employee, I let the official police do their investigation before I began mine.
Right, you do not aid in the collection of evidence.
No, that is not my job.
You simply read the reports of investigators.
Yes, that is what crime scene reconstruction entails.
But reading a report will never provide a person with the same degree of understanding as being on the scene or directly examining the evidence, correct?
Objection, Your Honor, argumentative.
Mr. Aragon?
Your Honor, this is cross-examination, so it's supposed to be argumentative to a degree.
Anything further, Mr. Alito?
I believe that this is more argumentative than most cross-examination questions.
May I respond, Your Honor?
You may. Go ahead.
This is also her statement from the witness, so it makes sense I bring it up in cross-examination.
So it goes to your credibility, and I'll allow some leeway based upon the testimony she's presented so far. It's within her scope. So overruled. Go ahead.
But reading a report will never provide a person with the same degree of understanding as being on the scene or directly examining the evidence, correct?
Yes, that is correct. However, I was able to go to the scene, but it was after the other investigators were there.
Okay, and after reviewing other people's report, you came to only one possible conclusion.
I said that it was the most likely scenario, yes.
Right, that the victim must have been alerted by the ring security system.
I said that was extremely likely. However, there is a small chance that that is not true. My job is to make sure that I address the most likely possibilities.
You also claimed that the victim then looked for a defensive weapon.
Yes, I believe that is the most likely scenario.
Then the victim then confronted the intruder.
Yes.
And stabbed the victim. Correct?
Yes, I believe that. That's what I said the most likely scenario was.
Let's now talk about the evidence, or rather lack of evidence, you base these conclusions on. First, do you believe the ring camera sent an alert to the victim's phone?
I believe that is highly likely. However, it is not the only possibility and not the only way that the victim could have been alerted that there was someone in the house.
Right, yet you have no evidence to support this assumption. Correct?
I do have evidence.
I'm sorry, go ahead.
The indication in the Ring doorbell with the back door shows that it is not an extremely quiet back door, and there's also evidence of a scuffle, which means that that's what I base my basis on.
Right, but you have no evidence that they had their phone on them and they got a Ring alert, correct?
Objection, Your Honor,
Yes.
asked and answered.
Mr. Aragon?
Your Honor, I was just clarifying to the witness as to what she was answering to. She was talking about the scuff marks, the Ring videos, while I was specifically talking about how the victim didn't have their phone and how she has no evidence for that.
So it's similar to the question you asked. I think you can go ahead and move on. Yeah, I'll overrule the objection.
A thorough and comprehensive investigation would have included obtaining phones from the Ring company. Records, excuse me.
Yes, however, I'm not an expert in cell phone analysis.
Right, those records would have told you whether it had the ability to alert the homeowner.
Yes, but once again, that is not within the scope of my expertise.
But a thorough and comprehensive investigation would have included a search of the victim's phone.
If I was an expert in that, maybe, but I did not. But I wanted to make sure that I knew what I was investigating.
Awesome. Let's move on to your final conclusion. To support your theory that the victim was aware that the intruder was about to enter, you rely on the scuff marks found at the scene.
I did not rely on that merely, but I did take those into account when I was coming to my conclusion.
That's a yes?
Yes, it is part of what I used.
Specifically, the scuff marks found on the kitchen floor near the back door.
Yes.
But you have no way of knowing when those scuff marks were made, correct?
Yes, that is correct.
Those scuff marks could have been there an hour before the intruder arrived.
Yes, that is correct. However, I deem that highly unlikely based on my professional opinion of how Brackman would have conducted his household after my analysis.
Thank you. You'll have to explain all your feelings in redirect. I just need a yes or no question. Even still, you believe these scuff marks indicate that at least 2 individuals were engaged in a struggle.
Yes, I believe that was the most likely scenario.
Even though the evidence shows the victim wasn't wearing any shoes.
Where is the evidence of that?
Exhibit 1, and I'm sure as the investigator in this case, you looked at Exhibit 1, correct?
Yes, that is correct.
So again, the evidence shows the victim was not wearing any shoes, correct?
Yes, that is correct. However, it does not pertain to the perpetrator.
Thank you. No further questions, Your Honor.
All right, thank you, Mr. Aragon. Mr. Alito, would you like to do redirect?
Who do you believe made the scuff marks at the door?
I believe that the perpetrator made the scuff marks at the door.
So then it's not directly relevant that the victim was wearing shoes or not, correct?
Yes, that is completely true.
Question.
I can rephrase that if you want, Your Honor.
Was Mr. Aragon, what was your objection?
I was objecting to my opposing counsel's question. At the end, they said correct. And since this is redirect, that is a leading question.
Okay, I'll sustain. You can go ahead and ask another question, Mr. Alito.
Is it relevant that the victim was wearing shoes or not?
No, it is not relevant to this case.
Thank you. No further questions.
All right, thank you, ma'am. You can go ahead and step down. All right, and prosecution, would you like to call your last witness?
Yes, Your Honor. The prosecution would like to call witness Alex Cifuentes to the stand.
All right, Ms. Alex Fuentes, please take the stand.
And Your Honor, if I may, just before I start, may I ask how much time I have remaining?
You may. Could the timekeeper alert Mr. Tours?
Mr. Tours, you have 5 minutes and 9 seconds.
Thank you so much. Please state your full legal name and spell the last for the record.
Alex Fuentes, Sifuentes.
Awesome. Thank you so much for being here today, Alex Fuentes. Alex, are you a student?
I am.
And what school do you go to?
CHS or Colorado High School.
What grade are you in?
I'm a senior.
Are you involved in any extracurriculars at CHS?
Yes, mock trial.
And do you have any friends in particular in mock trial?
Avery Becker.
How do you know Avery Becker?
We met my freshman year.
And did you meet defendant Avery Becker in mock trial, or was it outside of mock trial?
Outside of mock trial.
So are you two friends outside of mock trial?
We don't really hang out much outside of mock trial. We have pretty busy lives.
And how would you describe Avery as a member of mock trial?
Unmotivated and lazy, though pretty talented at making things up on the fly, but her antics did not hold up well with the rest of our team.
What exactly do you mean when referring to Avery's antics?
Well, Avery was always constantly late and constantly unprepared, leaving the team in a constant state of anxiety, but she really bit it in the butt when she, wrote on Coach Breckman's car with permanent marker.
So in referring to this incident, when exactly did that occur?
It was right after our regional tournament, the practice after.
And why exactly did this occur?
Well, Avery and Mr. Breckman got in another fight, and Mr. Breckman kicked Avery out of practice.
And how would you describe your relationship with Mr. Breckman?
I believe he saw me as a good, hardworking student and considered that when assigning roles.
And how exactly, from what you observed from being on the team, how would you describe the interactions or the nature of the interactions, between Mr. Breckman and Avery Becker?
Well, anytime Avery was late or unprepared, the tension between them would increase.
And did Mr. Breckman assign roles on the team?
He did.
And did you feel that he assigned them fairly?
Yeah, pretty much.
So did you feel any competition with Avery Becker?
Yes, we always pushed each other to be better.
Relevance.
If I may respond, Your Honor.
Yeah, go ahead and restate your objection, counsel.
My objection was to relevance to assigning assignments fairly on the mock trial team.
Mr. Tours, response, please.
Well, Your Honor, by this I'm just trying to assert the my witnesses' opinions towards Mr. Breckman and how they felt towards Avery Becker, because obviously that has been a very significant, their intentions and motives towards Avery Becker has been a very significant fact in this case. And so this is directly indicative of that.
Right. Mr. DeRose, anything further on that?
Yes, I also object to speculation, Your Honor. The attorney is asking the witness to speculate on Coach Breckman's fairness, which they do not have knowledge to.
If I may respond, Your Honor, I'm asking them to not speculate, but to say if they felt that that they were fair that their roles were assigned fairly to them. It's their opinion.
Okay. So what I'll allow Ms. Fuentes to testify to is her observations and her lay opinion about the assignments. But it may be helpful to the jury. So I'll allow some leeway. And Mr. DeRose, you can cross-examine her on that. I think there is speculation, and the jury should strike in not considering speculative statements from this witness. Go ahead.
For that, I'll move on, Your Honor. Would you say that you and Avery bonded over your visions for the team?
I would say that I cared more than Avery about mock trial. Her priorities seemed to be elsewhere compared to mine and those in the team. However, we did push each other to be better.
And do these differences make you feel differently about Avery as a friend at all?
Not as a friend, but it did.
Mr. DeRose, was that an objection?
Yes, Your Honor, I objected to relevance.
Again, Your Honor, I'm just trying to establish the relationship between my witness and the defendant, Avery Becker, because obviously they had a relationship in mock trial and out of mock trial, and this is directly relevant to any motives or intentions of my witness.
All right. Anything further, Mr. DeRose?
No, Your Honor.
Okay, similar to last time, I'll allow a little leeway here. It may be helpful to the jury, but let's stay away from speculation. Go ahead, counsel.
All right. And did you observe any tension in the team between Mr. Brackman and Avery Becker?
I did. As previously said, every time Avery was late or unprepared, the tension would increase.
And how did Avery, what exactly occurred after the incident with the marker that you mentioned?
Coach Brackman kicked Avery off the team for good.
And what exactly did Avery Becker do in response to this from what you observed?
She texted me asking to plead her case to Coach Brackman, and I did, and he said no.
All right.
And then,
so
I'm sorry, I'm finished.
No, you're fine. Thank you so much. Moving on to address exhibit number 14. Judge, if I may ask, was this submitted? I didn't exactly catch that in what was occurring in the first testimony.
Yes, 14 has been admitted.
Awesome, thank you. Let the record reflect that it is expected that the witness is looking at a clean and unmarked copy of what was previously marked as exhibit number 14. Ms. Fuentes, could you please explain to me what you see in front of you?
Yes, these are the text messages that Avery sent to me.
All right. And these text messages, what did these indicate to you?
Well, she told me that she was going to go to Coach Brackman's house while he was at work and trash it.
And you had seen Avery behave in a manner like this with Mr. Brackman before, or had you?
Yes, based on the marker incident, yes.
So from what you observed, he demonstrated a capacity for rash and vindictive decision-making?
Objection, Your Honor. Leading question.
Your Honor, I can rephrase my question.
Okay, go ahead.
So how would you perceive this towards Avery's general demeanor towards Mr. Brackman, these texts?
I could see how she has a strong dislike for Coach Brackman and has capacity for rash decision making.
And relative to Avery telling you his plans or their plans, when did you get the call from the police department?
I cannot remember exactly, but it was pretty soon after.
Awesome. No further questions, Your Honor. Thank you.
All right, thank you, Mr. Tours. Mr. DeRose, did you have any cross-examination of this witness?
Yes, Your Honor. And before I begin, could I just get a quick time check?
You sure may. Timekeeper, could you tell Mr. DeRose's time?
Mr. DeRose, you have 3 minutes and 12 seconds remaining.
Thank you.
You may proceed.
Good afternoon, Ms. Fuentes. Before we talk about, thank you. Before we talk about your time in the mock trial team, I just wanted to understand your relationship with Avery Becker a little bit better. According to you, you and Ms. Becker had a close relationship?
Yes, we did.
But you really only spent time together at mock trial practice?
Yes, we both had different lives.
Even though you claim to be Avery's best friend, you would ask Coach Brackman on several occasions as to why he put up with Avery's attitude.
Yeah, I was curious.
And after Avery rode on Coach Brackman's car, you believed Coach Brackman should have pressed criminal charges against Avery.
Yes, it was an act of vandalism.
even though you claim she was one of your closest friends.
My friendship with Avery has nothing to do about my feelings and about her actions.
Right, but you claim that she's one of your closest friends, correct?
Yes.
Speaking of mock trial, you feel that it's a slap in the face when somebody who doesn't work hard still gets the best attorney award?
Yes.
Especially because you feel you were equally skilled as team members.
I do feel that way, yes.
So you were glad when Avery Becker got kicked off the team?
Objection.
I was
lack of
glad that.
foundation. Objection, Your Honor. Lack of foundation.
Mr. DeRose?
Your Honor, this is not a lack of foundation. I'm simply asking the witness a question of whether or not she was glad that Avery Becker got kicked off the team. I'm not sure what further foundation I could have laid other than establishing that they were both on this team together and competed regularly.
So since you're cross-examining this witness, I'll allow the latitude to ask that question. I'll overrule that, Mr. Tours. Go ahead.
So you were glad when Avery Becker was kicked off the team?
Yes, I believe that the anxiety lifted off the team would be beneficial.
Right, because you were excited about the larger role you would have with Avery gone.
I guess that was a part of it.
And it works out better for you if Avery never gets put back on the team.
Objection, Your Honor. Argumentative.
Mr. DeRose?
Your Honor, this is cross-examination. I am allowed to be argumentative here.
Mr. Tours, anything further?
Yes, Your Honor. I understand being argumentative, but what the defense is doing is they're asking them a question that is asking them to accept one of their own summaries or conclusions. It's not actually testifying to any fact.
So I'm going to allow the question you can answer. I think it goes to bias and her relationship to the examination so far. It's within the scope. So you can go ahead and answer the question.
Thank you, Your Honor.
I apologize. Could you please repeat the question?
Yes, and it works out better for you if Avery never gets put back on the team.
I suppose.
Right, because you think the team is better off without Avery.
I believe the team is better off without her lack of preparation and tardiness.
Speaking of Avery being kicked off the team, let's talk about text conversations you claim to have had with Avery Becker. You claim that Avery Becker texted you that she had planned to go to Coach Brackman's house and trash the place.
Yes, she did.
Yet you never contacted the police after receiving this alleged text message.
I did not think of it at the time.
To report that somebody was planning to commit a burglary on your beloved coach.
She said trash.
Right, and an act that you agree that could potentially put Coach Brackman in danger.
Yes, however, she did say she was going to wait till Brackman was at work.
Well, you adored Coach Brackman.
I did, yes, very much.
You had never done anything that would put him in danger.
No.
Yet the very first time you reported those text messages to law enforcement was after Coach Brackman was murdered.
It was.
And only after Detective Markowitz reached out to you.
Yes.
Essentially,
Objection.
Avery.
Objection, Your Honor. Are we prosecuting Alex Fuentes? I mean, relevance is on my objection.
Mr. Droz?
Your Honor, and the time at which the witness reported these text messages to police is extremely relevant in this case. This is relevant as to what time she reported it. It goes to show her bias.
Mr. Tours?
I don't believe that the defense has laid the proper foundation to actually say that claim that this has leads to any bias or that my witness is even capable of this bias due directly to the fact that they did not report it. I don't believe that there has been a proper correlation or foundation set to establish that yet.
I think the testimony is sufficient to describe her actions. You can go ahead and move on. Mr. DeRose, I'll sustain that objection.
And only after Detective Markowitz reached out to you did you give the text messages to them.
Yes.
Essentially ensuring that Avery Becker would never get back on the mock trial team.
That's not my original intent, but yes.
How convenient. No further questions, Your Honor.
All right. Mr. Tours, did you have any redirect with your last couple seconds?
I do not, Your Honor.
All right. Thank you, Ms. Fuentes. You can go ahead and step down. And Mr. Tours, do the people rest their case at this time?
Yes, the prosecution people do rest their case. Thank you, Your Honor.
Great, thank you, sir. And is defense ready to present their first witness?
Yes, Your Honor. The defense calls Professor Van Owen to the stand.
All right, Ms. Bruckler, thank you. Professor, have you made it to the stand?
Yes, Your Honor.
All right, thank you. You can proceed.
All right. Good afternoon, Professor. Please introduce yourself to the jury by telling us your name and spell your last name for the court reporter.
My name is Blake Van Owen, Vanowen.
Before we get to know you a little bit better, let's find out why you are here today. What is your relation to this case?
I was hired by the defense to review the evidence and render an opinion as to how this crime occurred.
Before we get to your opinions, let's start by talking about your background. What do you do for a living?
I'm a professor, a private investigator, and I often testify as an expert witness in police procedures.
Tell us about your educational background.
I graduated with my bachelor's degree in English in 2004 from University of Colorado in Boulder, and about 10 years later, I got my master's degree in criminal justice at Asheville University.
That's a pretty big gap between your bachelor's and your master's degree. What did you do in between?
I became a police officer with the Aurora Police Department from about 2005 to 2006. And after I left APD, I worked in various other areas of law enforcement.
Give us some examples.
Well, I've also worked as a private security guard, a school resource officer, and finally as a private investigator, which is what I do now.
You mentioned earlier that you're a professor. Tell us about that.
I currently teach a class on police practices as an adjunct faculty member at the Community College of the Rockies. And for the past 5 years, I've also taught a course at CU Denver in police practices and social justice.
You also mentioned that you often testify as an expert witness. What areas have you testified as an expert in?
I've testified as an expert witness in the areas of use of force, false arrest, police practices, and forensic evidence techniques, as well as crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Are you compensated for your work as an expert witness?
Yes, of course. This is my career.
How much are your fees?
I charge about $225 an hour for my investigation work and research, and $450 an hour for my time spent testifying.
What courts have you testified in?
I've testified in the U.S. District Courts in the districts of Colorado, Kansas, and Arizona, as well as the state courts in Colorado, Wyoming, Nebraska, and New Mexico.
How many times have you testified as an expert?
In over 100 cases, at least.
You mentioned before that you were hired by the defense team to render an opinion in this case. Were you able to do that?
Yes.
What did you rely upon in reaching your opinions?
I've reviewed the police reports, the autopsy reports, the crime scene reconstruction conducted by Kyle Kuzak, as well as the cell tower reports and exhibits prepared by Detective Markowitz, and I've also conducted my own partial investigation into certain areas.
Are your opinions the products of reliable principles and methods?
Yes.
And did you reliably apply those principles and methods to the facts of this case?
Yes.
At this time, the defense moves to tender Professor Blake Van Owen as an expert in the field of crime scene investigation to include cell tower analysis and general police investigation tactics pursuant to Rule 702.
Brief voir dire, Your Honor.
Mr. Alito, voir dire.
Thank you, Your Honor. You are attempting to testify as an expert in police investigation tactics, correct?
That's correct.
Where did you learn about police practices?
I was a police officer, and I also taught courses on it.
And how long ago was your police officer job?
From about 2005 to 2006.
All right. And this is the same job that you left due to an incident with arrest, correct?
That is correct.
Objection, Your Honor. Improper character evidence.
Mr. Alito?
Your Honor, this is in the witness's affidavit.
Your Honor, I can talk about that. Just because it's in the witness's affidavit does not make it admissible evidence. I'm talking about this incident of her losing her job is improper character evidence.
No, but it could be relevant to the expertise of the witness as she did leave one of her jobs.
So allow little leeway here as it may go to her qualifications as an expert if that applies to her credentials. So I'll overrule that objection.
Thank you, Your Honor. You also plan to, you don't plan to testify as that. Did you ever go to school or take courses on crime scene reconstruction?
No, I did not, but I've testified many times as an expert.
You also plan to testify as an expert in cell tower analysis, correct?
That is correct.
And where did you learn about cell tower analysis?
It was part of my police training.
Your 9 months of police training?
That is correct.
Did you attend college or any classes related to cell tower analysis?
I have a master's degree in criminal justice.
Did that involve cell tower analysis?
Yes.
All right. Your Honor, the prosecution objects to Blake Van Owen being entering as an expert in cell tower analysis on the basis of lack of education.
All right. So can I take it that you don't object to the rest of her credentials and expertise, Mr. Alito?
No objection on the rest of the expertise.
All right. Ms. Bruckler, any response or further presentation?
Your Honor, we have laid significant foundation for this witness to be testifying as an expert in the field of cell phone data, as well as the other things that we've tendered her in. She has a myriad of educational experiences as well as experience in the policing field. Namely, she was a police officer for the APD. She was also a school resource officer. She's a private investigator. She has a plethora of background in this area and can testify to these, as she has done in many cases before.
Yes, Your Honor, while this is true, she has no education background or experience related to cell tower analysis, which is the only thing that the prosecution objects on.
All right. Thank you. Anything further, Ms. Bruckler?
I would just state again that she has experience working with this and training working with cell phones. And under 702, she needs one of those two things, not necessarily education like a college background.
All right, thank you. Well, the burden for expertise is not as high as one would think. I think I'll qualify her for purposes of this hearing here today, although I instruct the jury to note her training in the area of cell phone expertise, and they can give it the weight and credibility they believe is appropriate. Ms. Fox.
All right, Professor, let's turn now to your investigation. What conclusions do you draw from the evidence?
Well, I came to 3 conclusions in this case. The first, this was not a burglary gone bad. This was an intentional and premeditated
Excuse
murder.
me, sorry, Your Honor, objection narrative.
Oh,
Ms. Bruckler?
Your Honor, I didn't ask about the witness's day or anything. I'm not calling for a narrative. I'm simply asking her to give her concise conclusions in this case.
So,
May I respond, Your Honor?
Mr. Alito?
While that is true, it is a very open-ended question.
So I'll allow you to go ahead and proceed. Ms. Bruckler, just try to ask direct questions and kind of guide the testimony. Go ahead.
Sure. Professor, how many conclusions did you come to in this case?
I came to 3 conclusions.
Can you talk about those conclusions you came to?
Yes, the first was that this was not a burglary gone bad. This was an intentional and premeditated murder. The second is that there was no evidence tying this crime to Avery Becker. And the third, the police investigation was incomplete and therefore unreliable.
All right, let's talk about those conclusions, starting with the first. What led you to believe that this was not a burglary gone bad?
Well, one of the key pieces in Investigator Kuzak's claim is that there was a struggle between the victim and the intruder based off the scuff marks found at the scene of the crime. And that's it. That is the only piece of evidence that Investigator Kuzak provides for that claim.
So what's the problem with that?
Well, we simply have no idea when those marks were made. They could have been there 2 days, 3 days ago. Heck, they could have even been there 6 months ago. We simply have no idea when or how those marks were made.
So, Professor, what you're telling me is we have no idea if the scuffle was caused by a kerfuffle?
That's correct.
What else led you to the conclusion that this was a premeditated murder?
The murder weapon.
What about that murder weapon?
Well, the knife that was determined to be the murder weapon did not match the same style or brand from the otherwise orderly and same set of knives found in the victim's knife block in the victim's kitchen. This leads me to believe that the intruder
Objection,
brought
Your Honor, assuming facts not in evidence.
Ms. Bruckler?
I'm not really sure what we're objecting to here because these are all facts within the evidence.
There's no knife in evidence.
Ms. Bruckler?
The professor is simply talking about what she found when she came to the house. Again, the burden of proof is not on our side to put evidence forward. That is on the prosecution. So if there's no picture of the knife in evidence, that's not on us.
But
So
you are
I'll-
assuming facts not in evidence. Sorry, Your Honor.
It's okay. So for purposes of this hearing, I'll go ahead and overrule your objection based upon the affidavits that the parties have submitted. Noting the objection, Mr. Alito, but you can go ahead and proceed on your, Ms. Bruckler.
Professor, I'm going to re-ask that last question. What about this murder weapon indicated that it wasn't a premeditated murder?
Well, the knife that was determined to be the murder weapon does not match the same brand or style from the otherwise orderly and same set of knives from the knife block in the victim's kitchen. This leads me to believe that the intruder brought the knife with them, since it cannot be matched to any other brand or style in the knife block.
So if you believe that the intruder brought their own knife, how do you believe the victim was stabbed?
Well, we know from the autopsy report that the victim was stabbed at a downward angle. If the victim and the intruder were both standing up next to each other, the intruder would have had to been fairly larger than the victim in order to achieve that downward angle. However, we know from the ring footage that the victim and the intruder were roughly the same size, so that theory does not stand. Instead, it's my opinion that the victim must have been sitting down and the intruder must have come up from behind the victim and stabbed them from behind.
How do you conclude that the intruder came up from behind the victim when we heard testimony today that the victim was alerted by his Ring app?
Well, the prosecution assumes that the victim was alerted to the intruder entering the home because of the Ring security system sending an alert to the victim's phone. However, we have no evidence that the victim even received such an alert. Personally, I have a Ring doorbell, and you can turn off notifications like that. Detective Markowitz has not put forth any evidence as to whether the victim had their notifications turned on, whether the victim received such a notification, and frankly, whether the victim even had their phone on him at all.
So based on your investigation, the intruder came up, brought their own weapon, came up behind the victim, and stabbed them from behind, indicating what?
Objection, Your Honor, leading question.
Oh, Your Honor, I'm not offering an answer here. I'm asking what this indicates.
Why don't you go ahead and rephrase, Ms. Bruckler? You can re-ask it again.
Professor, what do your conclusions indicate to you in this case?
Well, this leads me to believe that this was a intentional and premeditated murder. The intruder planned to enter the home of the victim for the purpose of killing the victim.
Moving on to your second issue with Detective Markowitz's investigation, you indicate that there's no conclusive evidence tying Avery Becker to this crime. How did the detective tie Avery Becker to this crime?
Detective Markowitz relied solely on the cell phone records of Avery Becker on March 6, 2020.
Is there a problem with that?
Yes, there are many problems with that.
Like what?
Well, it's important to understand that cell phone records show the possible location of a cell phone and not of a person. For example, if you left your cell phone in a cab and someone were to check the cell phone records for that night, it would simply show the location of the cab's route and not of you because you were nowhere near your cell phone.
Is it rare for teenagers to not be with their phone 24/7 though?
Well, there was evidence presented to Detective Markowitz during his investigation that Avery Becker had lost her phone and did not have it the day of the murder.
Well, Detective Markowitz believed that Miss Becker had her phone, so following his assumption, why would this evidence still not be sufficient for you?
Well, assuming that Avery Becker was with her phone on the day of the murder, which we have no evidence corroborating, just because her phone connected to a certain cell tower does not mean that she was anywhere in the vicinity of that cell tower. Detective Markowitz's opinion is based solely on assumptions.
What do you mean? Sorry, my mom just interrupted us. If she'd like to finish this cross for me or direct for me, that'd be great. What do you mean by this evidence not being sufficient for you?
Well, there are two reasons. First, cell towers can cover very large ranges. Some can cover over 100 square miles. And two, cell phones are programmed to connect to the best tower for connection, which isn't always the closest tower for connection.
How does that affect the reliability of Detective Markowitz's opinion?
Detective Markowitz assumed that Avery Becker was with her phone on the day of the murder, which we have no evidence corroborating. But just because, let's assume that her cell phone was that she was with her cell phone the day of the murder, just because her cell phone connected to a certain tower does not mean that she was anywhere within the vicinity of that tower. His entire opinion is based off of assumptions.
Speaking of assumptions, you also mentioned that the police investigation was incomplete. Based on your expertise, what was this investigation lacking?
Well, how much time do we have?
Let's keep it brief, Professor.
Well, while we're on the topic of cell phones, Detective Markowitz should have obtained a search warrant to collect and search through Alex Cifuentes' phone.
Didn't the detective get information from Alex Cifuentes' phone?
Absolutely not. The detective simply accepted a screenshot of the alleged text conversation between Alex Fuentes and Avery Becker. Any reputable cell phone expert would know that this is unreliable.
What could the detective have done with a search of the phone? Oh, Professor, I think you cut out there for a second. Can we pause the time really fast? I can't hear her, at least.
I also can't.
Professor, let me ask that last question again. What could the detective have done with the search of the phone?
Well, as law enforcement, there are programs we can use to do what we call a cell phone dump, which is basically downloading all the context of a cell phone, including text messages. One of these programs is called Cellbrite, which Detective Markowitz has already admitted that she has access to.
In addition to the lack of investigation into Alex Fuentes' phone, what else did you find missing from the investigation?
A complete lack of investigation into any other possible suspects.
Well, is there any evidence of another possible suspect?
Absolutely. Even from my cursory review of the evidence, there was already one name that stood out to me as a possible credible suspect.
Who's that?
Blair Rollins.
Objection, Your Honor, speculation.
Ms. Brockler?
Oh, Your Honor, this is an expert witness. She's allowed to speculate.
Mr. Alito, anything further?
She's allowed to speculate about people that she's talked to.
Ms. Brockler?
Sorry, she's also allowed to speculate on the facts in this case, and part of her partial investigation that she conducted was into who Blair Rollins is. So this is definitely within her purview.
So I tend to agree. She reviewed documents and has been retained as an expert to comment on the investigation and give her opinion. So to the extent she's relying on the documents and information that was presented to her, she can answer that question. Overruled.
Professor, who's Blair Rollins?
Blair Rollins is the son of Jonathan Rollins.
Okay, who's Jonathan Rollins?
Well, Mackenzie Bracken was the defense attorney who represented Jonathan Rollins in court, who had been accused of murder. At the trial, the jury found Jonathan Rollins guilty and he was sentenced to life in prison.
How does that connect to Blair Rollins?
Well, Blair Rollins was present during the hearing, and there was also an audio recording of the hearing that I have personally listened to. After the sentencing, Jonathan Rollins yelled out that Bracken was going to die.
Objection, Your Honor, hearsay.
Ms. Buckler?
Your Honor, we're not offering this statement for the truth of the matter. We don't care really if Jonathan Rollins was actually intending to kill Mr. Bracken or if he meant that with truth. Instead, we're taking this as the effect on the listener, which is his son Blair Rollins that was in that courtroom.
Your Honor, this is still a statement made out of court.
I think it was technically made in court.
True. Not this court.
So for purposes of this expertise, anything she's relied upon making her opinion, I'll go ahead and allow her to testify and you can cross-examine her on that. Mr. Alito.
Professor, let's go back to that audio recording. Before you got cut off, what were you saying?
Sorry, could you repeat the question?
Talking about this audio recording you listened to, what did you hear in that?
Oh, after the sentencing, Jonathan Rollins yelled out that Bracken was going to die.
And what does that mean for your investigation?
Well, since Blair Rollins was present in the courtroom and heard that statement, Blair Rollins has a much more stronger motive to want to kill Mackenzie Bracken. A much stronger, more serious motive than just wanting to get back on a mock trial.
Objection, Your Honor, speculation.
Ms. Brockler?
Again, Your Honor, this is an expert witness.
All right, so I'll sustain the objection regarding to speculation, but she can testify to what she heard and her opinion, not the speculation of it. Right.
Detective, Professor, what other evidence, if anything, also pointed to Blair Rollins?
Well, Blair Rollins matches the same shape and build of the suspect in the ring footage. Blair Rollins was also absent from school the day of the murder and does not have an alibi for the time of the murder. Blair Rollins, even more suspiciously, essentially disappeared after graduation, and his whereabouts are unknown.
Yet, despite all of that, did the police ever investigate Blair Rollins?
No, they failed to do so.
Thank you. No further questions.
All right, thank you, Ms. Brockler. Mr. Alito, do you have cross-examination of this?
Yes, Your Honor.
You may proceed.
You were working for the defense as a private investigator, correct?
That is correct.
And you wrote a report concerning the conclusions made by Detective Markowitz and CSR Kyle Kuzak?
Did I review the reports? Is that what you were asking?
You wrote a report, right?
Yes.
You mentioned in your previous testimony that the knife used to kill Mackenzie Brackman did not match the others in the knife block, correct?
Correct.
Do you have Exhibits 7 and 8 in front of you?
I do not.
Can you get those out for me?
Yes.
Your Honor, and opposing counsel, do you also have copies of Exhibits 7 and 8?
I have a copy of Exhibit 7 and 8.
Thank you.
Okay.
Opposing counsel, is there a way for you to screen share and constructively show this witness Exhibit 7 and 8, even though they haven't been admitted yet, just without the jury?
Yeah, sounds good. Let me pull that up. I can't pull it up on a screen share, but I can show it to you.
You want to describe that, Mr. Alito, what you're showing us?
Actually, I was going to ask, can you describe this exhibit to me?
It appears to be a knife.
Objection, Your Honor. I'm just going to say best evidence. This hasn't been admitted into evidence.
That's what I'm trying to do right now, Your Honor.
Okay. Can he lay foundation for that then, please?
So I'm going to let Mr. Alito explore it. This witness testified that she reviewed all of the police records, and so I'll let her at least be shown them and see if she can describe them. But Mr. Alito, go ahead.
All right. Can you describe what is in this exhibit, Exhibit 7?
It appears to be knives in a knife drawer.
Thank you. And can you describe what is Exhibit 8?
That appears to be a knife block.
Is there anything particular about this knife block that's important in your investigation?
The knives in the knife block are otherwise orderly, same brand.
There's nothing else particularly important about this knife block?
In my investigation, no, I do not believe so.
You never heard about the missing knife from that knife block?
I mean, that's correct. There's a knife missing.
And you did read the report of Kyle Kuzak, correct?
That's correct.
In his report, he believed that that knife was missing and was used to kill Mackenzie Brackman.
That is correct. That is what his report says.
Yep. Taking a look at this knife block in Exhibit 8, do you notice the missing knife, correct?
That is correct.
Now taking a look at Exhibit 7.
Objection, Your Honor. If we're going to talk about evidence, can they admit it for best evidence? That's my objection.
Mr. Alito?
Yes, Your Honor. I'd move to enter Exhibit 7 and 8 into evidence.
All right, Ms. Brockler?
I'm going to object to lack of foundation.
Your Honor, the witness has explained that she knows what this knife block is, as well as the knife drawer, as well as in the police report that she received in order to investigate this crime scene.
Your Honor, for my lack of foundation, this witness did not collect these exhibits while she relied upon them in both of her reports. She was not the one to document these. That was Detective Markowitz. It'd be more fitting to admit these exhibits under Detective Markowitz during the prosecution side of the case.
Anything further, Mr. Beck?
Isn't enough foundation is what I'm saying, because this witness can't opine on the current state of this evidence or how it was collected.
It's also in the stipulated facts that the chain of custody of evidence is not disputed, or it's indisputed.
So for purposes of today's hearing, I'll allow those to come in. They've been referenced as exhibits and referred to by the experts. So for purposes of this hearing, I'll allow those to come in and you can examine.
Thank you, Your Honor. Taking a look at Exhibit 7, if you direct your attention to the middle left side of the drawer, do you notice a large chef's knife with a black handle and 3 white circles, yes or no?
Sorry, could you repeat that?
Taking a look at Exhibit 7, if you direct your attention to the middle left side of the drawer, do you notice a large chef's knife with a black handle and 3 white circles, yes or no?
Yes.
Now moving back to Exhibit 8, what color are the handles in these blocks?
They are black.
And do they also possess the same 3 circles as that knife in the drawer?
I cannot see this exhibit clearly.
If you could see it clearly. Okay, I'll move on. Given these facts, is it safe Is it a safe prediction that the knife missing from the knife in the drawer was the one missing from the block?
No, I do not believe so.
Okay.
Are you asking me to make a prediction?
I'll move on. You previously testified how the only signs of a struggle were the scuff marks on the floor, correct?
The only signs that I believe were indicative of struggle, and I don't even believe that that was really reliable evidence.
So the only signs of struggle were the scuff marks on the floor, in your opinion?
Yes, in my opinion.
What do you see in Exhibit 9?
I do not have Exhibit 9 in front of me. Exhibit 9 seems to be a broken plate on the floor.
Thank you. Can a broken plate be a sign of struggle?
It possibly could be. I do not believe in this case, with all the evidence around it, that this was indicative of any struggle.
So if it's not a sign of a struggle, how do you explain it?
Excuse me?
How do you explain the plate breaking if it's not a sign of struggle?
Your Honor, this seems like unsafe speculation for this witness to make. It's completely outside of the scope of her expertise.
Your Honor, this is exactly in her scope of expertise, as she is an investigative expert and can definitely speculate about something in a crime scene.
Ms. Buckler?
Yeah, asking the previous history of a plate in a crime scene, I don't think falls under the expertise, especially when this witness has already demonstrated that this was not indicative of a struggle to her. Instead, what opposing counsel is asking for her to speculate just about anything about the nature of this plate, it's too broad.
Your Honor, I can reword the question.
Yeah, I think you can reword it and see if she has any information about it as opposed to giving a speculative answer. Go ahead.
How do you believe that plate broke?
I am not sure how that plate broken. Somebody could have broke it. Somebody could have dropped the plate on the ground.
And you previously stated that it was a possibility the ring notifications did not alert the victim of the intruder's presence, correct?
That's correct. We have no evidence whether or not the victim received a notification.
So you also have no evidence that they did not, correct?
Objection, Your Honor, this is burden shifting.
Mr. Alito?
I'll move on, Your Honor. You talked about how the police failed to collect records from cell towers for the day before the murder, correct?
That's correct.
And you believe this piece of evidence was relevant to the case, correct?
Yes, it would have further corroborated and upheld Avery Becker and Taylor Perkins' claim that they had been searching for the phone.
And as a private investigator, you do have the ability to request these records, correct?
That's correct.
And you still did not do so?
Objection, Your Honor, this is also burden shifting.
Your Honor, I'm not saying that it is the responsibility of this witness to do so. I'm simply asking if they did so.
Ms. Bruckler?
Insinuating a responsibility.
So noting for the jury the burden shift, I'll overrule the objection if she personally did that or took the steps to. So you can answer the question.
So you didn't request those records, correct?
That's correct, but I didn't feel that it was my responsibility. Detective Markowitz, who is the lead investigator in this case for the prosecution.
Thank you, Your Honor. No further questions.
All right, thank you, Mr. Alito. Ms. Bruckler, would you like to do redirect?
I just want to give the professor an opportunity to finish her thought on that last question. What were you saying about Detective Markowitz's investigation?
Detective Markowitz's investigation had many holes. There were a lot of steps that Detective Markowitz should have taken to investigate further, not only collecting more cell data reports, but also searching for any more leads for possible suspects. Detective Markowitz's investigation was very incomplete and therefore very unreliable in this case.
I have no further questions.
All right. Professor, thank you for your testimony. You can go ahead and step down. And does defense have another witness they'd like to present?
Yes, Your Honor. The defense calls witness Taylor Perkins to the stand.
All right, thank you, Mr. DeRose. And Taylor Perkins, are you on the stand?
Yes, I am, Your Honor.
All right, good afternoon. She's your witness, counsel.
Good afternoon, Ms. Perkins.
Good afternoon.
Please get comfortable when you're ready. Tell us your name and spell your last name for the court reporter.
Taylor Perkins, Perkins.
Are you currently in school, Ms. Perkins?
Yes, I'm a freshman at CU Boulder.
And where did you go to high school?
I went to Colorado High School.
And in high school, were you a member of the CHS mock trial team?
Yes, I was.
Great. Let's talk about your time on the mock trial team. First, who are the other members on the team?
There was a group of us, which included my best friend, Avery Becker, and our coach, Mackenzie Brackman.
And what was your relationship like with Coach Brackman?
It was fine. We didn't really have any issues with each other, unlike Avery and Coach Brackman.
What do you mean by issues?
Well, Coach was always giving Avery a hard time about being not prepared, and she was the best lawyer on the team, but she did often do the least amount of work.
How did Miss Becker deal with Coach Brackman?
Well, Avery's been known to play silly little pranks on Coach.
Give us an example of one.
Well, one time after regionals, Coach Brackman was getting mad at Avery about not being prepared again, and Avery wrote with what she thought was a dry erase marker on his car.
And how did Coach Brackman react to that?
Well, unfortunately, it turned out not to be a dry erase marker, but a permanent one, so Avery was kicked off the team.
How did Avery handle getting kicked off the team?
Avery felt terrible about it. She tried to apologize to Coach over and over again, and she was really just trying to hope to get back on the team.
And was she ever able to get back on the team, Ms. Perkins?
No, she wasn't.
Let's fast forward a bit and talk about the day before Coach Brackman was killed, March 5th, 2020. Did you see Avery Becker that day?
Yes, we basically spent the whole day together.
And what did you two do?
Avery came over to my house, and then we went to the Fry Shack, then the mall, then back to my house.
And when you went to the Fry Shack, did you run into anybody that you knew?
Yes, we actually ran into the students from the mock trial team.
Did you talk to any of them while you were at the Fry Shack?
Yes, we sat with Alex Fuentes, and Alex and Avery spoke.
And did Alex and Avery appear to get along?
No, not really. In general, Alex just always seemed really jealous of Avery's success on the team.
You mentioned that Alex and Avery spoke at the Fry Shack.
Yes, until Avery stormed off.
What do you mean stormed off?
Well, Alex was telling Avery how unfair it was that she got kicked off the team, but Alex...
Objection. I'm sorry, objection, Your Honor. Hearsay.
Mr. DeRose?
Your Honor, this is not hearsay. We're not offering the statement for the truth. It doesn't matter whether or not it was fair that Miss Becker was kicked off the team. We're offering this to show why Miss Becker stormed off.
Right. Anything further, Mr. Tours?
Well, Your Honor, I do feel that the witness, I'm sorry to interrupt, but I do feel that the witness is testifying to what other people said who did not directly testify to that. And so I believe that that's inherently hearsay, but that's all I have to say. Thank you.
Right, thank you. So noting it may be hearsay, I think there's enough exception to allow you to go ahead and continue, and the jury can take note of that.
What do you mean stormed off?
Sorry. Well, Alex was telling Avery how upset she was, how Avery got kicked off the team, and she was just saying it in a really insincere way, and she was being really passive aggressive. And I saw Avery, and she looked up really upset, and she went into the bathroom.
And did Alex Fuentes stay at the table?
Yes, along with Avery's phone at that time.
And what did you do?
I just went to go get Avery, and then we went to the mall.
Did you two go anywhere else that day?
No, just the mall, then back to my house.
Okay, let's turn now to the following day, March 6th. What did you do that morning?
Avery came over to my house to pick me up in the morning.
And where did you two go?
We were supposed to go to school, but I told Avery how I kept calling her over and over again that morning, and we realized that her phone was actually missing, so we went to retrace our steps.
What do you mean retrace your steps?
Well, we first went to the mall and went to all the stores that we went to the previous day, and then we went to the Fry Shack, and it still wasn't there.
To your knowledge, did Miss Becker ever find her phone that day?
No, we kept calling it over and over again, and we never were able to locate it.
Now, were you with Miss Becker the whole day on March 6th?
Yes, I was.
And at any point on March 6th, did you or Miss Becker go to 444 South Flower Street?
No, we were nowhere near there.
And at any point on March 6th, did you or Ms. Becker come into contact with Coach Brackman?
No, not at all.
No further questions at this time, Your Honor. Thank you.
All right, thank you, Mr. Droz. Mr. Tours, cross-examination.
Yes, Your Honor. First of all, thank you so much, Ms. Perkins. I'm just going to ask you a few questions regarding everything. So, from what you observed, Avery didn't much like Coach Brackman, correct?
No, yeah, they had a lot of issues with each other.
And you had some issues with Coach Brackman as well, correct?
I wouldn't say that we had really any issues. I just never really liked him as a coach.
And do you believe that you were a good asset for mock trial team?
Yes, I was.
And you felt the same about Avery?
Yes.
So much so that in the event of Avery's removal from the team, you stepped down so he could have your position, correct?
Yes, well, I mean, Avery was the best lawyer on the team, and mock trial doesn't really mean that much to me.
And would you say that you did this for Avery Becker?
Yes, and for the better of the team, we were never going to win without Avery.
Right. I would just like to ask, do you have the your witness affidavit in front of you?
I do not, but I can get it.
All right.
Okay, yes.
You do? Awesome. Thank you so much. If you could possibly read lines 40 to 41 for me.
Objection, Your Honor. This is an improper impeachment.
Mr. Tours?
Your Honor, I'm simply asking her to read some lines from her affidavit so that I can ask some further questions regarding it without it being speculative. I'm not actually attempting to impeach the witness.
Your Honor, if I may.
Mr. Droz?
The attorney has not confronted the witness with her testimony and given her a chance to admit or deny anything. So therefore, reading from her witness statement in this case is not relevant at all. There's no need to read it. It's cumulative. It speaks for itself. And if there's any disputes, then he can try to impeach this witness. But as of right now, we should not be reading her affidavit.
Certainly, Your Honor. I can ask the question first.
Sure, why don't you do that, and then you maybe can rely on our affidavit, Mr. Tours. Go ahead.
Absolutely. Thank you so much for the clarification. So, Ms. Perkins, you believed that Alex, that Alex thought it was not a permanent marker, but an expo marker, correct?
I'm sorry, do you mean Avery?
Avery, I'm so sorry. Yes, Avery Becker.
Yes, she definitely thought it was a temporary marker.
And you believe this because Avery told you that?
Yes.
And you stated in your affidavit that you don't think it's fair that Avery got kicked off the team for vandalizing Mr. Brackman's car, correct?
No, I mean, she still had the skill set to be on a team, or to be on the team.
Yet you acknowledge that Avery did vandalize Mr. Brackman's car, regardless of intent?
Yes.
So do you not believe that crimes such as vandalism deserve any consequences when it comes to your friends?
I mean, I do believe that vandalism is a crime, if that's what you're asking, but I do believe Avery offered to pay for the car paint job, and she just felt really terrible about it. So.
Yet you did not believe that Avery deserved the consequences that he got.
Well, I believe that Avery was still skilled enough to be on the team, yes.
You do. So that's a yes?
Yes.
Awesome. Thank you so much. Moving on, Ms. Perkins, you weren't very fond of Alex Cifuentes, correct?
No, not really.
And you even stated in your affidavit that you had to restrain yourself from instigating physical violence with him, correct?
I mean, I wanted to, it was just in the heat of the moment, and Alex was being really rude. I would never actually punch her in the face. I was just, it's a figure of speech.
And you didn't like that Alex was trying to take your friend Avery's role because he was in the place to take his role, correct?
I'm sorry, can you repeat that question?
Your Honor, that was
yes.
a question.
Your Honor, I'm sorry, I can break that question up.
All right, go ahead.
You didn't like that Avery was trying to take your friend, or that Alex was trying to take your friend's Avery's role, correct?
No, Avery was much better at mock trial.
And moving on, Ms. Perkins, what led you to believe that Alex might have taken Avery's phone and forged the text?
The fact that Avery lost it with at the Fry Shack while it was right next to Alex, and we were never
And
after that fact.
And this is because Avery told you that that's what happened, correct?
No, I was there when she lost the phone.
But the inference that Alex Cifuentes took the phone, you believe that because Avery Becker told you that, correct?
Question, Your Honor, asked and answered.
Your Honor, this was not directly answered. I asked it, but the answer to this was not answering the question at all.
So for purposes of clarifying for the jury, why don't you re-ask it one last time and then move on from that question, Mr. Torres? Go ahead.
Absolutely, Your Honor. Thank you so much. Ms. Perkins, you believed that Alex might have taken the phone because Avery Becker told you this, correct?
I mean, yes, we both thought it.
And do you have any direct evidence of this beyond hearing it from Avery Becker?
No, just what I saw. I mean, I saw that the phone was with Alex.
Your Honor, this is burden shifting. Counsel is asking the witness about providing evidence, which is not her role in today's case.
Your Honor, yes, if I may respond, I'm simply asking, I'm not asking them to provide any evidence. I'm asking if there's any evidence in existence that has been submitted to the case that they're aware about or that they witnessed that is included within their affidavit.
Anything further, Mr. DeRose?
Yes, Your Honor, that is exactly what I'm saying. This is burden shifting. He's asking the witness about presenting a piece of evidence. It's not her role to search out any other additional pieces of evidence. She's not a detective. She's not reliable to bring in any evidence in this case, and therefore that question is inappropriate.
Your Honor, if I may, could I restate the question?
You may. Go ahead, Mr. Torres. We'll sustain.
Ms. Perkins. Awesome, thank you. Sorry. Ms. Perkins, you don't actually have any evidence beyond, you or Avery don't have any actual evidence that Alex might have taken the phone, correct?
Again, it's just what we saw.
All right. And no further questions, Your Honor.
All right, thank you, Mr. Torres. Mr. DeRose, any redirect of this witness?
Yes, Your Honor, briefly. Ms. Perkins, is it your job today to present any evidence to the court?
No, it is not.
Thank you. No further questions, Your Honor.
All right, thank you, Ms. Perkins, for your testimony. You can step down. And I believe we're moving to our last witness. I did see a note that perhaps prosecution has a member that may be ill. Could somebody just give me an update? I want to make sure Mr. Lowry can proceed.
Yes, Your Honor. Mr. Lowry cannot proceed today due to an illness, so I will be taking his role for right now, if that is permitted by everyone.
All right. So we just want to note for the list of who's doing what that you're going to take over from Mr. Lowry. Okay.
Yes. So I will be I will be crossing Avery Becker and objecting to the direct examination of Avery Becker.
Thank you. We hope Mr. Lowry feels better. All right. Defense, your next witness.
Thank you, Your Honor. The defense calls Avery Becker to the stand.
All right. Thank you, Mr. Aragon. Mr. Becker, have you joined us?
Yes,
Ms. Becker, I apologize.
no worries.
Ms. Becker, you're the defendant in this case. Just to make sure you want to testify here today, you know you have the right to remain silent?
Yes,
Okay. And you're choosing to testify?
yes.
All right. I'll let you go ahead and proceed with that then. Counsel?
Thank you, Your Honor. Good afternoon, Ms. Becker.
Good afternoon.
Tell us your first name and last name and spell your last name for the court reporter.
My name is Avery Becker, Becker.
Now, before we get into the details of this case, let's address the question on everyone's mind. Did you break into Mackenzie Brackman's home?
No,
Did you ever physically assault Mackenzie Brackman?
no,
And Ms. Becker, did you kill Mackenzie Brackman?
absolutely not.
Now that we've gotten that out of the way, let's learn more about you and your relationship with Coach Brackman. How do you know Mackenzie Brackman?
I was on the Colorado High School mock trial team for the last 4 years, and he was my coach.
What was your relationship like?
We didn't always get along. We disagreed.
How so?
Well, he didn't think I worked hard enough. that I didn't ever put in the effort, which I disagreed with.
Were you always at each other's throats?
I wouldn't say always. I mean, through mock trial, I was able to gain a lot, and it's something I'll always cherish.
Did you hate Coach Brackman?
I wouldn't say hate. I mean, I don't think he liked me very much, but I didn't hate him, and I can't believe he's gone.
Did these disagreements ever come to a head?
I would say maybe right after the regional mock trial tournament.
What happened?
Well, I had won Best Attorney Award, and I also had won an award for closing. But to do that, I pretty much had to go off of the scripts that he wanted me to stay on track with.
How did Coach Brackman handle that?
Well, he just laid into me about how I didn't deserve any of the awards that I had gotten, that I was being lazy, I was bringing the team down. But what hurt me the most was that he said I only relied on my good looks.
Why did that bother you the most?
It was just like a really uncomfortable comment for an adult male to make about a female student like myself. And it was just unwelcome and made me feel bad.
How did you handle that, having your coach tell you these things?
Well, I was just really upset, angry even, and I was tired of being insulted, so I left.
What happened when you left?
I went out to the parking lot and I had seen his car, and I still had a dry erase marker in my hand from practice, and I wrote on the hood of his car, Worst Attorney Award. I come to find out that it was actually a permanent marker, not a dry erase marker, and that was by far the dumbest thing I've ever done in my life.
How did Coach Brackman find out about his car?
Well, he came up behind me, and I turned around and he just exploded.
What do you mean by exploded?
Well, he was yelling at me and he was just really upset.
What did he say?
He said, "What the hell have you done to my car? That's it, you're kicked off with the team."
How did you respond?
Well, I was really sad. Mock trial means so much to me, so I went home to my mom and I just cried and cried.
Did talking to your mom help?
Yeah, for sure. I mean, it provided some clarity, and I realized that the next morning I was going to go to his office and try to apologize.
How did he take your apology?
Well, I went to his office, and his secretary said that he was busy. So then I tried to text him saying I would repaint his car, try to get it scrubbed off. But he just, yeah.
Did Coach Brackman ever respond?
No, he didn't respond, and I was devastated.
Why are you devastated?
Because I never got the chance to apologize before he was killed.
Well, speaking of the murder of Coach Brackman, let's talk about your whereabouts that day. Where were you on March 6th?
I was with my friend Taylor Perkins the entire day.
How did you and Miss Perkins, what did you and Miss Perkins do all day?
Well, that morning I had realized that I didn't have my phone, so we decided to skip school and look for it.
How did you look for it?
We retraced our steps, so we went to the Fry Shack, the mall. We tried calling my phone using her phone and just kept going straight to voicemail.
Did you at any point go to Coach Brackman's house on March 6th?
Not to my knowledge. I don't even know where he lives. And also I was preoccupied the whole day looking for my phone.
Ms. Becker, you've been sitting here throughout the entire trial, and you've heard testimony from all the witnesses. Now, one of those witnesses, Alex Cifuentes, is claiming that you texted them that you plan to go to Coach Brackman's house to trash it. Did that happen?
No, I never sent any of those texts.
Did you want to get back at Coach Brackman?
Initially, I think when I first got kicked off the team, I said something like that to my mom, but I meant that more of like embarrass him or prank call him or something. But even those feelings change.
What do you mean those feelings changed?
Well, mock trial meant everything to me, and the only way to get back on the team was to get back in Coach Brackman's good graces, and I wouldn't do anything to jeopardize that.
Thank you. No further questions, Your Honor.
Thank you, Mr. Aragon. Mr. Tours, would you like to cross-examine this witness?
Yes, I would, Your Honor.
All right.
Thank you so much for being here today, Ms. Becker. I'm just going to ask you a few questions pertaining to this case and everything that occurred. Ms. Becker, would you say that you and Mr. Brackman got along?
We didn't always get along. No.
And you mentioned that Brackman made remarks regarding your laziness and poor work ethic, correct?
Yeah, and to the whole team, it was really embarrassing.
And you got demoted before regionals, correct?
I did.
All right. And this was upsetting to you, correct?
Of course.
Upsetting enough to you to vandalize Brackman's porch?
I got demoted before regionals, and then I ended up getting put back on to the A team. I was upset when I vandalized his car, which was the stupidest thing I ever done. I did that because that was after the regional tournament when he was insulting me.
So that's correct. I'm sorry. And so referring to the Porsche incident, you were kicked off the team, correct?
Yeah, I was demoted to the B team. I was demoted to the B team before regional.
And
sorry, where's like the timeline? I'm confused by your question.
I'm sorry, I'm referring now I'm referring to the Porsche incident where you drew on the
Okay.
car. And were you more upset about being demoted to B team than you were about being kicked off the team?
I mean, I was upset both times, of course.
Okay. And I'm sorry if you'll excuse me, Elizabeth. And you acted in violence and broke the law that day, correct?
I did not act in violence.
Would you say that vandalism is not violence?
I mean, I'm not hurting anyone. I don't think that is violent.
Would you say that regardless of your intentions, that it was still breaking the law?
It was the dumbest thing I ever done. Yes, I wish I hadn't done it.
Action, Your Honor.
So-
she doesn't know the rule. She's not a legal expert. She doesn't even know the rule of law or what's legal and what's not.
Mr.
Your Honor, vandalism. I mean, I think we're going to assume that this is coming from a general perspective of someone who's involved in a team who obviously deals with legal matters, and knowing that vandalism is a crime is a very commonly and ubiquitously known to be a crime in the United States. So that's the perspective that I'm coming from, Your Honor.
May I respond?
Mr. Aragon, anything further?
Yes, again, with co-counsel's response, they even said we're going to assume that this is common knowledge. So in that sense, it is speculation regardless. She's not a legal expert, so she doesn't know the ins and out when it comes to vandalization. Overall, this is speculation.
All right. Well, what I'll allow you to do, Mr. Tours, is we'll reference, just for purposes of this record, that traditionally the laws and rules are public knowledge and there's public notice. To the extent you want to explore her belief that she did something wrong, I'll allow that. So go ahead, you can proceed.
Thank you, Your Honor. So you would say that you had hard enough feelings against Mr. Brackman to break the law?
I was upset with what he had just done to me. So that's why I vandalized his car.
All right. So is that a yes or a no to the question?
Can you repeat the question?
That you disliked Mr. Brackman enough to break the law?
In the sense of vandalizing, I did, but I wouldn't do anything else.
And you state that you told your mom about this incident, correct?
No, I didn't tell her about the car incident.
But did you not mention that you stated to your mom that you would get Mr. Brackman back if it was the last thing that you did?
I did initially.
All right. No further questions, Your Honor.
All right, Mr. Tours, thank you. Mr. Aragon, would you like to have any redirect with this witness?
Yes, Your Honor, a brief redirect. So why did you vandalize Coach Brackman's car?
I was really tired of being insulted after the mock trial regional tournament. So that's why I went out, and it was just the heat of the moment. But I also thought it was a dry erase marker, and it was the stupidest thing I ever done. I, of course, wish I could take that back.
Right, and we've heard co-counsel mention this. What did you mean by saying that you wanted to get back at Coach Brackman? It was the last thing that you did.
I mean, I think that was just in the moment I said that. And even like I said, those feelings changed. And the number one way to get back on the mock trial team was to get back into Coach Brackman's good graces. So I wouldn't do anything to jeopardize that.
Thank you. No further questions, Your Honor.
All right. Thank you, Mr. Aragon. Ms. Beckman, thank you for your testimony, and go ahead and step down. Does the defense rest?
Yes, Your Honor, the defense rests.
All right, thank you. Anything further on behalf of the prosecution before we proceed to closing arguments? Mr.
No, Your
Tours?
Honor.
All right, thank you. So let me give you a moment to take a deep breath, and then whenever you're ready, Mr. Alito, I'll allow you to make your closing argument.
Thank you, Your Honor. Ladies and gentlemen of the jury, today you have heard much about the murder of Mackenzie Brackman, a skilled litigator, a mock trial coach, and above all else, an irreplaceable staple in the community he lived in. You discovered through testimony today that this wasn't the first time there had been conflict between Becker and the late Brackman. For months upon months, Avery Becker had been slacking off on the team, which led to fights with Coach Brackman. While Avery wanted nothing more than to retain the lead roles on the team while doing the absolute bare minimum, Brackman understood that it simply wouldn't be fair to the other members of the team to let that negligent and lazy attitude continue to prosper. So as always, Brackman did what was right for the team and demoted Avery on the grounds of carelessness. As revealed by testimony from Alex Cifuentes, Becker's response to this decision demonstrated a magnificent show of character with the decision to maliciously vandalize Coach Brackman's car. Once more, Brackman did what was right and expelled him, Becker, from the team. Avery, albeit understandably so, had many issues getting over this. So on March 6th of last year, after days of dealing with anger and humiliation, Avery Becker texted Alex Cifuentes that she had the intent to get even with Mr. Brackman by going straight to her own home, to his own home, to vandalize it. Shortly after that, Brackman was discovered stabbed to death near his front door. One thing is for certain, simple coincidence is not to blame for this wicked crime. Through the testimonies and evidence you have heard today, we are completely faithful that you, the jury, will understand your civic duty in finding Avery Becker guilty in today's trial. Today, you have heard the testimony of 3 individuals from the prosecution, one of whom used to be a close companion and teammate of Avery Becker, and the other 2 expert witnesses here to better explain and lay out the many pieces of evidence that prove Avery Becker is beyond a reasonable doubt guilty and the perpetrator of the 2 charges we bring against her today: murder in the first degree and second-degree burglary of a dwelling. Firstly, you have heard from expert witness Jordan Markowitz, a homicide detective with the Denver Police Department with a certification in data recovery from the American Academy of Law Enforcement. By meticulously following the data evidence, Markowitz explained in detail the events of the day of Brackman's murder. First, he explained the location of Avery's cell phone being at the scene of the crime during the time the crime was committed. Then further proving his case by showing the text between Mr. Cifuentes and Avery Becker, showing obvious intent of breaking and entering. Secondly, you have heard from expert witness Kyle Kuzak, a crime scene reconstruction investigator with 19 years of experience and a certification from the Colorado Bureau of Investigation, who provided his explanation in detail of his theory of the events of March 6th. First going through the gruesome details of Brackman's stabbing, then following with the odd circumstances surrounding Brackman's reaction, suggesting that he knew the person threatening him, as well as his professional opinion on what exactly occurred. Finally, Alex Cifuentes, a close friend of Avery Becker who spent considerable time with him in both mock trial and outside the club, testified to Avery's character, detailing the bias that Avery always held against Mr. Brackman. And finally, the unsettling text that he received from Avery immediately before Mr. Brackman's murder, again proving Avery's intent to commit burglary. While the defense may lead you to believe that there is insufficient evidence to conclude with absolute certainty that Avery Becker was the one who murdered Brackman in cold blood, this is simply untrue. Cell tower evidence places Becker at the scene of the crime during the time that it occurred. It seems to be a little too big a coincidence that the person accused of murder's phone seemed to have gone missing the day before a violent crime occurred. I have confidence that you, the members of the jury, will not let the defense's misdirection sway your opinion, and that the evidence given today proves beyond a reasonable doubt that Avery Becker is solely and completely responsible for the death of Mackenzie Brackman. Remember that even if Avery had no original intent of killing or even hurting Brackman during the break-in, but still ended up doing so, you must find the defendant guilty of first-degree murder by Colorado law. We, the prosecution, have the cold, hard evidence. We have the most likely outcome. And right here today, we have a murderer awaiting sentencing. Now for you, the jury, you have only one thing. You have the opportunity to choose facts, to choose evidence, to choose justice. Today, you have the opportunity to rightfully hold Avery Becker accountable for her deplorable actions and find a verdict of guilty for the charges of murder in the first degree as well as burglary of the second degree. Thank you all for your time.
Thank you, Mr. Alito. Ms. Brockler, would you like to make defense's closing argument?
Yes, Your Honor.
You may proceed.
The prosecution just told you to choose facts, to choose evidence, and to choose justice. The prosecution gave you no facts and no evidence, so your last option is to choose justice, and that justice is finding Avery Becker not guilty. The prosecution has made us sit through an entire trial today with 2 charges that they brought against Avery Becker: burglary in the second degree and murder in the first degree. The prosecution, in bringing those charges, has the burden of proof. They accept that burden of proof, and they have not met that burden of proof. You should be outraged that they brought someone here and are putting charges against them that they have no proof to substantiate. Let's talk about the simplest way to meet your burden of proof in a case. The very first thing you have to do to even get to the threshold of burden of proof. That's identifying the defendant, identifying the person that you are accusing of this crime. Out of the 3 prosecution witnesses, 2 of which are experts, not a single one identified this defendant in the courtroom today. That should be means to acquit this case alone. Avery Becker is not guilty. Let's talk about the other evidence or lack of evidence that the prosecution has. The prosecution's case started and ended with Avery Becker. Their first lead was their only lead, and they stuck with that and just stuck whatever evidence they found to Avery Becker. From the crime scene, they collected no DNA evidence, no fingerprints, no hair follicles, no clothing fibers, even though they had the option to collect DNA evidence. You heard from Detective Markowitz that she chose not to collect DNA and blood evidence. So after finding no leads at the crime scene, their next reasonable lead was to go to the high school mock trial team and look into the drama there. That is unreasonable. Let's talk about the text messages that they used. The one piece of evidence that launched their investigation against Avery Becker. These text messages are not from Avery Becker. They're unsubstantiated claims. Avery Becker did not send those. She does not have a motive. Let's talk about the call detail records. Seemingly the only thing that the prosecution has, the only fiber that their case rests on today, their call detail records. Putting aside the fact that you heard from all 3 expert witnesses today that call detail records are not an accurate measure of location or GPS and cannot tell you where a person is at the time, and putting a fact aside that you heard that Avery Becker did not have her cell phone since March 5th, which was before the murder, the prosecution wants you to tie Avery Becker to the scene of this crime, but they can't tell you when this crime was committed. They want you to hold Avery Becker accountable for her location for the entire day, but they cannot tell you when this crime was committed. How are you supposed to hold Avery Becker accountable when they can't tell you when she was supposed to be committing this crime? There is no evidence here. The case that the prosecution has put forth is a joke. So much so, and they know that they didn't meet their burden of proof because they were asking all 3 of our defense witnesses for proof to exonerate themselves. The prosecution knows that they didn't meet their burden of proof, so they had to ask 2 17-year-olds and a professor to investigate their case for any exonerating evidence for Avery Becker. Look, what you've heard today is an instance of a rushed investigation. That's just what it was. This was a rush to judgment. It's your job to make this a rush to justice. Find Avery Becker not guilty. There is no burden of proof met. There is no evidence tying her to this crime. Find her not guilty and tell the prosecution and the police to go out there and find the actual criminal responsible for these crimes and to hold that person responsible. Tell them to do their job. This was a rushed investigation, a rush to judgment. Make this a rush to justice. Find Avery Becker not guilty.
Thank you, Ms. Brockler. And I've called you Alito because of the team, but it's actually Mr. Ayotte.
That's my mistake, Your Honor.
That's okay. For purposes of stating your real name, Mr. Ayotte, you have 32 seconds of rebuttal on the scope of the defense argument, if you like. Go ahead.
Thank you, Your Honor. The defense is right. There isn't DNA and blood evidence. The defendant wore gloves. Avery Becker has a motive, no reliable alibi besides her best friend, and the means to commit murder. She matches the body type of the perpetrator, and she has and she missed school that same day. Please see through the defense's misdirection and declare Avery Becker guilty of all the crimes we have charged her with today. Thank you.
All right. So big, deep breath and congratulations. I know you can't see all your screens, but I'm sure there's a lot of people out there clapping for you right now. Well done. Congratulations on your presentation. Now we're going to take up giving the scoring panelists, known as the jury, time to score you folks. And Mr. Che, how are we doing? What do we need to take care of here?
With respect to Mr. Lowry not being able to compete in the competition, that does affect the scoring for the scoring panelists. So pursuant to Rule 2.2.3.1 of the Colorado Mock Trial Rules, Mr. Lowry, because he wasn't able to finish his portion of the presentation, has to be scored with all zeros. And Mr. Aragon has to be scored with all tens for that particular round. So for the scoring panelists, we don't have the discretion under the rules to give different scores than that. And so when you're scoring, you're instructed to give those scores for that last set of examinations. Mr. Tours substituted in for Mr. Lowry, but because he had already presented in that round, those points for Mr. Tours' performance can't be scored to the Alito team.
Okay, that's good to know. We'll let the scoring panelists work on that. So you guys made it through 4 rounds, and I thought your presentation was really well done. And I know probably the scoring panelists would like to make comments. So to the extent they are able to, I'll give you a couple things that I noticed. And as I indicated, I've been litigating for a long time. I've done everything, homicides all the way down to traffic tickets. And this actually makes me more nervous doing this type of hearing because you guys are working so hard. And the rules of evidence apply differently in this case. You could see sometimes I was hesitating on how I wanted to rule because I really want to let you just present your case. So I thought you guys did a really great job. One thing I think that would be helpful, particularly when you move on to the next round, and I'm sure you both will, and I'm hopefully you will, is, foundation was brought up quite a few times. Something to think about when you're addressing the exhibits, like exhibit 14, 15, the knife exhibits, etc. Ask that person to look at that exhibit and if they know what it is. And then ask them how they know what it is. And I think I forget who had the objection, but the next thing is it an accurate reflection of the exhibit? Now, it could be that they saw it in person or that they reviewed the photograph before and this is a copy or the original, but ask them if it's an accurate representation of the exhibit. And then you can ask them to admit it. I did note, I think the gentleman who left, Mr. Lowry, he was a little ill. But one thing you guys might have noticed, and you want to not forget this, he tried to bring in about 3 or 4 exhibits. They kind of got frustrated by Ms. Brockler's objections there. Don't forget to circle back around. If you've offered an exhibit, make sure you have a checklist or something so you don't move on and forget about it. And, objecting sometimes can be helpful. It can throw the other party off as they're really cruising. But, when you're in court, you've got to make your objections that are good faith. Sometimes you have to decide, that's not really worth objecting to. I probably could. I'm going to let it go because you don't want to be necessarily objecting to everything if it's not relevant or it's not going to help your case. but objections sometimes can throw the other party off. There's a couple times where examination, the answers and questions were coming so fast, and you guys have done it so long, you're doing a great job. There were times where objections could have been thrown in to throw off that kind of repertoire. So just use your objections wisely, don't overuse them. And I think if you all work on presenting the evidence, you could get in a few more things without objection. Otherwise, I think you guys did an awesome job. Mr. Shea, I don't know if you were able to watch them and you had any comments. You've probably been bouncing around a little, but.
Well, yeah, and we're working on trying to get all the scoring done. I understand there's a problem with the form, and the lowest score that judges might be able to give is a 1, and so that's something that we can do. But with respect to the presentations today, you all did an excellent job. I've decided that to the extent that any of you are seniors, I'm going to have to retire from the practice of law in about 7 years, because I don't want to face all of you guys in court. So good job today, and I really appreciate all the work you put in this performance. Somewhere around 1994, 1995, I was in the Colorado high school mock trial in Arapahoe County for Inglewood High School. So, you know, this is where you'll end up if this is something that you decide to do. If you stick around a little longer, you might end up in the black robe in the chair next to me. And, you know, keep those things in mind as you guys are going on. When you get the opportunity to be lawyers, think about what mock trial meant to you and your ability to be able to mentor other people in the same way that Judge Hurst has been a mentor to a lot of us who have appeared in front of him, and in the same way that these volunteers have been able to sort of show up and devote their time on a Friday or Saturday to hearing your stuff. It's always a pleasure for us. But keep that in mind as you're moving forward, that you know, you guys have the great impact as you move on younger folks in order to be mentors for things like that. So that was all I had. I didn't make specific comments on anyone's stuff today.
Yeah, those are great words of advice, Mr. Shea. You know, we often say this during the mock trials, that you guys are better than a lot of the attorneys that come into my court, because you have the passion, you're trying to learn, and you know, you should really be proud of yourselves in your presentation. One thing I would recommend, and I know it's easy and you guys are probably more tech savvy than I am, but I know nowadays you could probably put your written closing argument or your written questions right up on the screen and look at them. When you're in the courtroom, you absolutely can carry around your notepad and look at them. You can absolutely look at your notes when you're arguing to the jury. That's completely fine. But sometimes you'll find that it can be distracting as well. Now, I don't know if you proceed forward on the next level or if you end up in the championship, which I think is, we don't know, is it going to be virtual, Mr. Shea, still?
I believe it is, yes, Your Honor.
Yeah, okay. For those who move on next year, though, you'll actually probably be back in the courtroom and in front of real life humans. So just next time you come around, if you do this next year, for those who aren't seniors, practice doing that in front of, say, your family at a Thanksgiving meal or something like that. Do your closing argument this year to them just for practice, because if you do it next year, it can be a little more nerve-wracking. So that's just another word of advice. So I'm really honored that I got the chance to spend some time with you guys, and I wish you all the best of luck, and thanks for letting me be here. So Mr. Shea, I guess we'll wait for the scorers to come on if they like and give their comments if they choose to. Otherwise, I'm going to go ahead and just work on a few rulings here. Did anybody have any questions? Oh, Ms. Newman's here. Hi, Ms.
I
Newman.
just wanted to say something because I did get to see some of the contestants from Breyer this morning, and they took the critique from this morning and really utilized it very well. And I want to say you guys did a great job, much better this time around. You slowed down, you were very articulate. You were just more prepared, I think, the second time around. And I was very, very impressed with that. With that being said, I think everybody did a great job, and thank you so much. I really enjoyed this.
I just like to add, I'm an attorney, but I am not a litigator. So I was even more impressed with the job that all of you did today. I wouldn't be able to do half as well as you did. So kudos to everyone, and Braden stepping in like that at the last minute. That was impressive. So thank you. Echoing what the judge said, as a non-litigator, the handling of the exhibit seemed a little bit awkward at times for both sides, I guess, and particularly the prosecution. I think you want to make sure you get your exhibits in when you have the best witness there to identify them and authenticate them. And I thought we grade you on professionalism. I thought both teams did a great job of showing respect to the court, to fellow counsel, and to the witnesses. So I gave you both high marks for that. And should you choose law as a career, I think all of you will go a long way in this profession. I've enjoyed it my almost 50 years now. And it's been a very rewarding profession, and I hope you consider it for your future as well. You've all got the talent to succeed, I think.
I don't know if Mr. Freed, you wanted to make any comment? You don't have to, but.
Well, I'm not a lawyer. I don't play one on TV, but I have participated in this before. It's my second year. I was a court monitor last year, and I have to say the efforts that went into this was extremely noticeable. The witnesses were spectacular. The lawyers were great. I just thought this was, given the facts of the case, that what came out of today's court efforts was spectacular.
I agree. All right, with that, Mr. Shea, I guess we turn it over to you to do whatever you need to do to move us forward. I want to congratulate you all. Best of luck. Stay healthy, and I'm sure you're going to go far in life. You guys are awesome. So take care and have a good day.
And folks, I'll terminate the live stream here. My understanding is that Courtroom 1 will have the live stream of the presentations with respect to the winners in the contest. So check with your coaches if you need information about that. And I'm going to go ahead and end the recording and terminate the session so you all can log off. Thank you.
Thank you.
Thank you.